We are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome everyone to the Massachusetts Appeals Court on this Tuesday, April 13th, 2021. This is courtroom A3, our virtual courtroom A3. If you're looking for Judges Mead, Willahogen, and Massing, you are on the wrong channel. You should go back to YouTube and type in Massachusetts Appeals Court again. I get that. However, if you're looking for us, I am Justice Joseph Ditkoff, and with me today is Justice Sabita Singh and Justice John Englander. And we'll be hearing the 5 cases that we have today. We'll be doing a sound check between each case, so we'll come off the live feed for just a minute or two. If everything works out, maybe a little longer if things are not working out, and then come back. We'll probably take a break after the 3rd or 4th case, depending on how things go, but I'll certainly inform you of that. It would be a short break in any event. I know you're both experienced counsels, but the little Massachusetts Appeals Court seal will be replaced by a countdown timer once we get underway. We have had some problems with the timer, but we will be paying attention. We'll make sure you get your time if something goes wrong. Don't worry, we don't have the nice yellow, but it will show up red when time is up. As you know, there's no rebuttal in the Massachusetts Appeals Court, and we have read the briefs, we have read the appendices, and we are familiar with the case, and you can get right to your case. With all that said, I'll call the first case today, Commonwealth versus Rogers, number 19P 1523. We'll hear first from Attorney Smith. Attorney Smith, you have the floor.
Thank you. Good morning, Your Honors. Joseph Smith for Mr. Rogers. May it please the court. With respect to my first argument, the Commonwealth in this case failed to adequately authenticate the surveillance footage from 17 Walnut Street. As we know from the teaching in Commonwealth versus Connolly, generally speaking, in order for a proponent of video surveillance evidence to properly authenticate it, one would need either testimony from a percipient witness of the events that are allegedly recorded, or testimony from someone that's familiar with the procedures, the procedures and methods themselves used to store and reproduce the video material. Here we have neither. While it is true that in certain instances, other circumstantial evidence could be used to authenticate video surveillance evidence, in this case, the Commonwealth failed to do that. So as is outlined in our briefs, the Commonwealth in this case attempted to authenticate the Walnut Street videos with testimony from a property manager of an adjacent property, if you will, and along with a detective that later investigated the scene of this shooting incident. So with regard to the property manager, that was Mr. Falkenstein. He was the manager of 21 Walnut Street, had no prior familiarity with the surveillance system at 17 Walnut Street, although he had something of a business acquaintance type relationship with the property manager of 17 Walnut Street, and Mr. Mario. Mr. Mario did not testify at trial. And in part, the Commonwealth relied on the testimony of Falkenstein to try to authenticate these videotapes themselves. The Commonwealth relies heavily on Commonwealth versus Chin. I think that case is distinguishable from the case at bar.
Counsel, is it your position, I'm sorry to interrupt it, but I'm literally sitting here staring at the video from 17 Walnut Street.
Yes, sir.
That depicts someone doing something in the back of 21 Walnut Street. Is it your position that the person in charge of the surveillance system at 17 Walnut Street, or someone with familiarity with that system, had to testify in order to authenticate the video footage?
That's not an absolute prerequisite, but generally speaking, that would be one way for the Commonwealth to have authenticated the video.
But that didn't happen here. So now we're looking at a video that someone can say that is a true and accurate representation of the back of 21 Walnut Street. as it appeared on that day, right? Someone can say that.
Well, they could, but that's not enough to get the Commonwealth to proving by a preponderance of the evidence that the video
What
itself.
more do they need?
So they would need, so in this case, they had Mr. Falkenstein testify. He was not a precipient witness to the events in question. He only.
So your position is they would need a precipient witness, someone who can say this is what happened on that day at approximately this time?
Again, that's another way. So essentially, there could have been three ways. One, as we just referenced, someone familiar with the surveillance system itself and the methods by which that video is stored and reproduced, or a precipient witness that saw the events in question that could authenticate the videotape. These are the methods referenced in Commonwealth versus Conley, or in certain instances, other circumstantial evidence could establish authenticity, but that's not what we have here. So,
haven't we had cases where someone has actually viewed the videotape and that's been held sufficient? Yes, I've previously seen this videotape that was taken from this this camera. Hasn't that been sufficient?
Well, those are the facts in Conley, and that in fact wasn't sufficient. So in Conley, the officer testified that he had viewed the video, but for whatever reason, the video itself had been lost or was never reproduced. So the Commonwealth attempted to have the officer in question testify as to what he had viewed on the video without actually producing the video at trial, and that was inadequate. In terms of justice,
but this is a case where the video was produced, and essentially we had witnesses indicating that the area that was depicted was that they were familiar with that, and that was the area that was depicted. There was evidence of the angle of the camera where it would have captured video. All of that wasn't sufficient?
Well, Your Honor, there are no date or time stamps in the Walnut Street videos. So
Can't that be tied together with what was actually depicted? The individuals, the clothing that they were wearing?
It's theoretically possible that it could be tied together in a circumstantial sort of fashion, but my argument is that in this case, Commonwealth failed to do that. With respect to
it wasn't tied together when you connect it with the school video.
So there's no continuity of progression. So the school videos themselves depict allegedly Mr. Rogers and some other individuals earlier in time that day with regard to the events in question at the Walnut Street location. But we don't have continuous video footage from the Ferryway school videos to the location itself of 17 Walnut Street. That's in contrast to Commonwealth versus Chin that the Commonwealth relies on, where in that case there was a video compilation with four surveillance footage from four separate locations. The primary, or I would argue the most important video footage is admitted in that case without objection. But in that case, the compilation, the other surveillance footage pieces had timestamps on them, although they seem to have been inaccurate. But the officer in that case was able to somehow, using his cell phone, come to an approximation of how far off the times were. But in any event, if you look to Chin, that's an example of, an instance where it appears the Commonwealth was able to establish by circumstantial evidence the video's authenticity. But they did so in a way where we have sort of a continuity of progression of a particularly distinctive vehicle traveling along a particular route. So in my brief, I call that, or I reference that as an interlocking
But the
mosaic.
difference that you fix on is really that there's a timestamp and that there was testimony about the timestamp, right?
Well, that's important.
Because here we have a progression. We have the progression here. We have someone with the clothes that are seen behind 21 Walnut Street. We have that person who someone testifies and identifies as your client in the school at 203, on the street between the school and 21 Walnut Street at 235, right? So we have the progression here. And really what you're fixed on is that there's no date and timestamp on the video that shows the back of 21 Walnut Street. Or am I missing something?
No, Justice Englander, I think that's important. It's quite important that there aren't any date and timestamps. But I would disagree to some extent that there's the same kind of progression that we have in a case like Commonwealth versus Chin, where we have 4 separate surveillance locations, and it almost fits together like a flip book of still images where when you flip them together, you can see a continuity of progression. Like in Chin, we have this distinctive vehicle. In this case, there's a
preponderance of the evidence standard, right?
That's correct.
That's all that we need is a preponderance of the evidence to find authenticity.
Yes, Your Honor.
Okay. And it's abuse of discretion standard with
Correct,
respect
Your
to the judge's determination as to whether it should come in?
That's accurate. Yes.
Okay.
But I think that in this case, it's important that we don't have the same type of continuity of progression. We have far less than that. So to depart from the general standard, which is either in order to authenticate a video.
I'm stuck on that. I don't understand why there's a difference, at least not one that causes me to think that one decision is an abuse of discretion and the other one isn't. I mean, we have someone with these same clothes in 2 different locations, proximate to 21 Walnut Street, between, at the first 2 are time stamped. So there's a progression. Your issue is I still don't, you're as I understand your argument, you're essentially saying to us, even if you accept that the first 2 are fine and that there's some sort of progression, you do not know what you're looking at when you look at the video without date and timestamps. You literally don't know what you're looking at.
Your Honor, because of the fact that there's no date and timestamps, we don't know. We don't know. I mean, it's somewhat obvious, but we don't know when this occurred. So this
you can't make inferences.
I think that
from what's happening on the video itself.
I think that under these facts, there needs to be more for the judge to satisfy his gatekeeping function in deciding whether to admit certain evidence. And I think that the Commonwealth's case of Chin that they relied on is readily distinguishable from the facts we have here. I see that my time is somewhat running short. I just would like to briefly touch upon my other argument, which is the issue.
Before you do that, can I just bring you back to one other question?
Of course.
Is there in the record anything that tells us where the bullets were found? The live bullets were found.
So my understanding is they're located in the parking lot itself.
Right, but whereabouts in the parking lot? Is there some diagram that identifies where the casings were found as opposed to where the bullets were found?
No, Your Honor, there wasn't a diagram per se. They did admit still photographs of the bullets themselves, but to my knowledge, there wasn't a diagram that depicts the precise locations of the bullets relative to where they were found.
Did the police officers testify as to where they found them?
I don't recall whether they gave.
I can ask your brother. I mean, it's more his issue than yours, to be honest. But
I apologize, Your Honor. I'm somewhat drawing a blank on that in terms of the precise locations of the bullets.
Okay, thank you.
Thank you, Your Honor.
You were moving on, and I.
Oh yes, I'm sorry. Just briefly, Your Honor, with regard to the sticky Post-it note. So as I argue in my brief, where we have an image published to the jury of one of the bullets, and there's a sticky note, and it essentially says Devante Rogers bullet with an exclamation point. My argument is that the trial judge in this case abused his discretion by failing to declare a mistrial, which repeatedly trial counsel requested. I think that ordinarily, I think the cases state, of course, that ordinarily speaking, a curative instruction is enough to alleviate any prejudice that might occur, and that's adequate, and then that should prevent or alleviate the judge from needing to declare a mistrial. But I think in this case, under these particular facts, the prejudice to the defendant is such that
Counselor, what is the prejudice?
Well, in contrast to what the Commonwealth's analogy is that it's the same as the complaint, and the jury's instructed to disregard the complaint, so that's enough. My argument is that it's distinguishable from that in the sense that unlike an ordinary charging document, a criminal complaint, this is a very peculiar sort of it's a sticky note on a particular bullet in a packet of 38 photographs where the evidence is very circumstantial, and we're really the only thing that's
It's not a picture, wasn't it? It was a photo, not a bullet, right?
well, it's a photograph of a bullet.
Okay, yeah.
And the sticky note says Devante Rogers bullet with an exclamation point.
So you're saying the jury might have taken from this some special significance that someone on the inside knows that this has been identified as his bullet, and now they're being told.
Precisely, Your Honor. So my argument is that the jury's perception of that is that this is essentially the work product of the prosecutor, and that they have sort of inside knowledge that this, in fact, was the bullet that Mr. Rogers possessed, and in fact, he's convicted of possession of ammunition and not of any of the other charges. So it's in a sense ineradicable that we have this, unlike a criminal complaint, which a jury would expect to, I think, have referenced in a criminal trial, and that they're instructed to disregard that ordinary charging document. We have a peculiar exhibit where it's singled out with one sticky note that this is Devante Rogers' bullet and emphasized with an exclamation point. So whether or not the Commonwealth was culpable in that or not, or it's just simple inadvertence, because of the ineradicable prejudice that Mr. Rogers suffered because of that, I would argue that any sort of curative instruction is inadequate under these facts.
Yeah,
But there's more than a curative instruction, right? They were individually polled.
They were individually voir dire to see whether they had seen it, or to inquire whether they had seen it. 5 out of the 6 jurors, in fact, saw the sticky note, and then as a whole, they were given essentially a curative instruction that they should disregard.
Can you cite? I know your time is up, and I also think I know the answer to the question, but I'm going to ask it. Can you cite a single case where curative instruction has been given and this court or the SJC has held that it was inadequate, and that what the jury had seen was ineradicable?
As of now, I'm not aware of a case on point that does hold that, but I think that this case ought to be that case.
Okay.
Thank you very much. Unless there's any further questions. Great, thank you very much. We'll hear from the Commonwealth now. ADA Ditkoff, the floor is yours.
Thank you, Rona. Good morning, and may it please the court. My name is Konstantin Ditkoff. I'm an assistant district attorney with the Middlesex County District Attorney's Office. I represent the Commonwealth. In this case, the trial judge did not abuse his discretion when he determined that a rational jury would, by a preponderance of the evidence, find that the surveillance videos admitted in this case were depicting the incident in question.
That's a question for him, counsel? That doesn't sound like the issue, whether a rational jury would find that. I thought the issue was whether he's determined by a preponderance of the evidence that the authentication standard has been met.
That is correct, Your Honor. And if I read,
so it's not a question of whether he thinks the jury might find that. It's a question of whether he's found that in his gatekeeper role, right?
Your Honor, yes. I guess this could be phrased differently. My reading of the case law is that the judge in deciding this particular matters is sort of asked to stand in the shoes of the jury and decide whether or not they would determine by a preponderance of the evidence. But regardless of how we phrase that, Your Honor, the incident in this case involved a shooting that occurred in the city of Malden at 2:49 p.m. on January 21st, 2018. And the defendant does not appear to dispute in the brief that the surveillance cameras depicted that precise location where the shooting occurred. The question is whether or not the video were depicting the incident in question. And here, the surveillance videos were mounted on 17 Walnut Street, which is the property immediately adjacent to 21 Walnut Street parking lot. And the manager of that property, Mr. Carmine Mario, he sent the surveillance videos from that location on that.
How do we know that? How do we know that?
from the testimony of Officer Keefe of the
Who
Malden.
said I received some videos? He didn't know who sent it to him, did he? How could he testify who sent it to him?
He did testify that that's on page 97 of volume 1 of the trial transcript. Officer Keefe testified that Mr. Mario sent the video to the Malden Police Department. And then Detective Lanny, that's in volume 2, testifies that Officer Keefe forwarded the videos to him and he watched them as well. Andrew Falkenstein, who is the manager of 21 Walnut Street, he testified that on the date of the incident, Mr. Mario invited him to 17 Walnut Street. He pulled the surveillance videos from the surveillance system before the eyes of Mr. Falkenstein, and he allowed Mr. Falkenstein to watch the videos, and Mr. Falkenstein identified the videos, which at that moment were admitted for identification purposes only, as the exact videos that Mr. Mario showed to him. Importantly, Your Honor, just turning to what Justice Englander asked my brother, there is in fact testimony about the location of the bullet in the parking lot. That is page 121 of volume 2 of the trial transcript, and also can be found on page 61 of the record appendix. Page 61 of the record appendix shows the
your appendix or your friend's appendix?
The defendant's record appendix, Your Honor. On page 61, there is a screenshot of Google Maps with the letters L and S on it, and they respectively identify the places where the live and spent casings were found. And then on page 121 of the second volume of the trial transcript, Detective Lanny, who made those markings on the map, which was admitted as an exhibit, he testifies that those are the locations that are seen on the video. So
that's volume 161. Is that what you're telling me to look for?
In terms of the record appendix, Your Honor, let me just very quickly double check. I believe it is volume 2, page 61, but I believe the pages are consecutively paginated.
Volume 2, page 61, but there's going to be no map there. Where am I going to find the map?
That would be the map, Your Honor. It says Google Maps 17 Walnut Street. I'm looking at it now.
There's maps on the third, fourth, and fifth page of the PDF of the second appendix. You know which one? They're not really clearly labeled. Which one are you talking about? The first map, the second map, or the third map?
Your Honor, I would be, if I could share the screen, I could just demonstrate to the court. It is page 5 in PDF format of the second volume of the appendix.
You know what? I don't think we want to interrupt your argument that much over this right now, because it's going to take too long. But were the live ammunition found, if you're looking at from the video camera at 17 Walnut Street, was the live ammunition found to the left of the staircase?
The live ammunition was found, I'm not sure, I do not recall the staircase, but it is essentially—
No, there's a staircase in the back of 21 Walnut Street.
Yes.
If you're looking from 17, from the video camera on 17 that shows that back parking lot, is live ammunition to the left of the staircase?
If you're looking at the staircase from the parking lot, yes, I believe that would be to the left. And if you actually look at the video, Your Honor, you will be able to see that where the defendant sort of leans towards the ground and picks a rectangular object, which the Commonwealth's case was that it was a magazine. That is the location where the live bullets were found, and the jurors heard the testimony that if the magazine is dropped on the ground, bullets will come out.
Thank you. That's helpful. Thank you. I want to go back to something you said earlier, just to try to understand the significance of it. So after the incident, Falkenberg or Falkenstein, I thought it was Falkenberg, he meets with Mario, and he testifies that he has shown a video from 17 Walnut Street. Your statement was he testifies that the video that is then shown to the jury is the video that he was shown by Mario?
He testified, Your Honor, that was on the first day of trial, at which point the videos were admitted for identification purposes only. So at that time, that was on voir dire. Mr. Falkenstein testified that Mr. Mario showed him those videos, and those were the videos that he himself, the discs with which he labeled with his own hand, And that was what was admitted for identification purposes at that time.
But that was done in a motion, that was in limine, that wasn't done before the jury.
That was done on voir dire, yes. Jury was not present at that moment, Your Honor.
Okay. I mean, this is a real stretch, counsel, in my view, and you're doing an awful lot of piecing together and asking for inferences, and that's why I'm pushing, at least, to really understand what you have.
Yes, Your Honor. We have a shooting incident. We have the police that arrives to the scene 5 minutes later. On the scene, they locate the bullets and the spent casing in the locations. In two locations, the defendant is seen running from one to another. In the location where live bullets are found, the defendant on the video is observed leaning towards the ground, picking up a magazine and running away.
Right, but what the inference that you're asking us to draw, and that you're arguing, the inference that you're arguing that it was legitimate for the judge to draw, is that this video that you're now talking about, the defendant is seen here, the defendant is seen there. That video is a true and accurate representation of something that occurred at 2:49 on that day. There is nothing in the video that tells us that. And there is no witness who tells us that that's a true and accurate representation of what occurred on that day.
Your Honor is undoubtedly correct that there is no direct evidence to authenticate the video here, but the case law teaches us that just as the Commonwealth's case can rest entirely on circumstantial proof, the authentication of the video can rest entirely on circumstantial proof. And in addition to the elements that I just mentioned, the school videos that were admitted without objection, they show the defendant accompanied by the same individuals, all wearing the same items of clothing. They're shown at school at 2:03 p.m. They're shown going outside of the school at 2:35 p.m. The weather conditions are the same. It's a bright, sunny winter day in Malden. And then those same individuals wearing the same items of clothing are running off the parking lot. And the school which again was admitted with no objection, which has timestamps which were accurate. The school principal testified to that. The school is located 150 yards from the location where the crime occurred. So in this case, I think Chin, despite the fact that my brother relies on technicalities to distinguish it, I think it's really on point, because we do have the surveillance video that was admitted without objection. We do have the continuity of progression of the defendant, same items of clothing, same individuals who are also wearing the same items of clothing from one location to another.
The difference is in every one of those cases, somebody comes in and says, this video here with this timestamp has an accurate timestamp on it, or has a timestamp that's inaccurate, but I can tell you what it was. I can tell you that it was this day at this time.
Yes, Your Honor. But again, even putting the school video aside, although it was an important piece based on which the judge could make that decision, and again, the court reviews for abuse of discretion and preponderance of the evidence. It's sort of a hybrid standard of review. I think it's definitely met here, especially given the fact that you see the defendant running in the parking lot from one location to another, and in those two locations, the bullets are found 5 minutes after the shooting. It's definitely a reasonable and possible inference. Is it inference based on circumstantial proof? Yes, but it's a fair inference on the preponderance of the evidence that this is in fact the video of the shooting, because
well, it's not the video of the shooting. In fact, it starts after the shooting.
That is correct, Your Honor.
For what reason? I mean, we have no explanation for why it starts when it does. We have nothing, because we don't have the person who actually was the person who was in charge of the video.
Yes, Your Honor, we did not have that person. We did summons him. He did not appear in court. But again, just faced with the evidence, what we have, and the defendant was convicted of unlawful possession of ammunition here. And I think that evidence, I mean, the sufficiency issue is not raised in the defendant's brief, but going back to the authentication of the video issue, I think that is plenty circumstantial evidence for a judge to conclude by preponderance of the evidence that the video in fact showed the incident in question. If I may, unless there are further questions as to the first issue, I would like to briefly turn to the...
What is your best case, Chin?
Pardon me, Your Honor?
What's your best case for being able to find authentication of a video that has no date and time stamp on it and the custodian of that video doesn't testify? What's your best case? Is it Chin?
I would say Chin. I would also cite Rogers, which was also recently decided by this court. I know that the Supreme Judicial Court granted a further appellate review in that matter, although after watching the oral argument, I think the oral argument was mostly followed by the precision of the GPS monitoring devices, my understanding was. So I'm not sure how relevant Rogers would be, but that would be my sort of my second best case. And again, Your Honor, in addition to that, the mountain of case law that says that it is possible to authenticate any evidence, including video evidence, on circumstantial evidence alone. There is no requirement whatsoever that there must be direct evidence to do that. Going back to the issue of mistrial in this,
The case you're just telling us about, Rogers, it appears that the court is concerned that they're not going to potentially not going to allow authentication of GPS evidence without somebody who can testify in a custodial or knowledgeable capacity about the technology.
but that is a different, I would say that that is
different technology because the video technology is more accepted at this point than GPS?
I would say, Your Honor, in this case, it's in the case at bar, which is again about the abuse of discretion and the preponderance of the evidence, the standard of review is more forgiving. And again, there is in the opinion.
Oh, no, look, the issues are the same. The issues are the same. Someone comes in and testifies to what technology has shown happened in a GPS context or in a video context. You're dependent on the technology, and generally we have someone come in and testify to the accuracy of the technology.
That is correct, Your Honor. And in this case,
and we don't have that here, do we, counsel?
There was no issue at trial that the videos were in fact depicting the back of 21 Walnut Street and its immediate vicinity. The question is only whether or not the time of the incident was properly depicted.
Well, but isn't there a question as to whether it accurately depicts, quote unquote, the incident?
Yes, absolutely, Your Honor. And the judge had to
Which is why we usually have someone say, that's a fair and accurate representation of what happened. Now, granted, in the context of video, we've gotten away from that because we allow video to show us what happened, even though someone may not have seen it happen.
I understand that, Your Honor, but again, presented by all the circumstantial evidence in this case, including the physical evidence found on the ground, the appearance of the defendant, the same appearance of the same individuals accompanied him, the timestamp of the school video that was admitted without objection. I think that circumstantial evidence was more than enough to persuade any jury or any judge by a preponderance of the evidence that the surveillance video in fact depicted the incident in question. I see that I'm out of time. I would just briefly state that the judge did not abuse his discretion in refusing to declare a mistrial because he provided a timely and curative instruction. And unless the court, yes,
brief on that, and certainly will be submitted unless there's any questions from my colleagues. Wonderful. All right. Well, thank you both. This is a really interesting case. It was really well argued and really well. It takes a second. Are we live?
Just a moment. And we are live and on the record.
Wonderful. Thank you very much. All right. I will call the second case of the day, Commonwealth versus VALOY, number 19P 1839. We'll hear first from Attorney O'Meara for the defendant. You have the floor.
Thank you, Your Honor. Please, this is the court. There's two issues in my brief. The first issue was error for the trial judge not to grant a mistrial in this case. And the second issue is arguing a required finding issue that the judge should have allowed required finding of not guilty. I'd like to, if it's okay with the justices, rest of my brief. Of course, any question you might have on that second issue, I'd be happy to answer. Well, the prejudicial remark made in this case was not a vague reference as argued by the Commonwealth. It was a direct remark that there were prior problems with the defendant, defendant's conduct during prior babysitting jobs, essentially. I realized that the court gave a limiting instruction, but I think it's recognized that there's some skepticism that jurors actually in some cases follow limiting instructions. If you look at Commonwealth versus DiMarzo, which is cited in my brief, I think the court recognized that once a jury hears a prejudicial statement like that, or any other statement, that it's hard for them to unhear it. So I think that's what the situation was in this case.
But counsel, there was no more specific reference than previous problems. I mean, there was nothing about the question that was asked that would give the jury any indication of what previous problems may have meant.
Well, I think my notes say the question was, what was your impression of how he was as a babysitter? So, I mean, that's pretty much a direct, clear question. And counsel continued, no issues that you know of. And then the response was, yes, about the previous problem. So, in my mind, if you put the question and the answer together, there were problems with him being a babysitter. And the jury heard it. And there was the curative instruction was disregard the statement, which was rather perfunctory in my mind. So again, if you look at DiMarzo, what they say about curative instructions, you can't discount the fact that a thought was planted in the minds of the jury. This guy, had some previous problems, and he, some behavior that wasn't quite right. The Commonwealth's case was not a strong case. It was a very weak case. And, I think it would only take something like that type of prejudicial statement that might sway the jury to convict. In this case, he was indicted on 3 counts. The 2 most serious counts were he was acquitted on. And the 3rd count he was found guilty on. A lesser included offense. So if you take a look at the factors again that's mentioned in DiMarzo for harmless error, if you look at those 5 factors, it would seem to me that it meets the 5 factors for a non-harmless error. So it's I've had a few cases like this where there's no witnesses in this case. There are no physical evidence. I've had a few cases like this, and it seems to me that it wouldn't take much. I think this kind of offending prejudicial statement would lead the jurors to that forbidden inference that this defendant is guilty of something here. So I think it's a very very delicate situation in a case like this, with the Commonwealth's cases.
Can I just ask this question was asked by the prosecutor, right?
Yes, Your Honor.
So the prosecutor's the one who said no issues that you knew of.
Yeah, I asked, what was your impression of how he was as a babysitter? No issues that you know of, correct, Your Honor. And then the response was, yes, about the previous problems. So yes, well, there were previous problems.
The prosecutor know about the previous problems? Is there anything in the record that indicates the prosecutor knew about the previous problem?
Not that I could find, Your Honor.
Okay.
So, this as I said before, this is a very close case. What's troubling about these type of cases Your Honor, is that in older, when sexual abuse cases of minors, when there is a huge delay in the reporting, I'm not telling the justice anything they already know. There's a I think it's after 29 years of after the offense, there's a corroboration requirement, and I think it's you know, if I was to argue a change in law, I would say that, you know, in cases like this where you have a young complainant and the defendant, and it's testimony. It's not even a duel of credibility. It's two testimony. It's one side testimony. The defendant very rarely testifies in cases like this. So there's some testimony, sometimes from the child themselves, and it's difficult to square that with whether where's the meat, aside from if there's no physical evidence and there are no witnesses, it's the nature of the beast. Yes, you're right.
I mean,
absolutely.
I think we're well past that problem, right? I mean, if a victim comes in and testifies, this is what happened, that can be sufficient to go to the jury. That can be sufficient to convict the defendant. I mean, the problem here that you're focusing us on first is whether there was some suggestion, some evidence that he had done this before. And did you watch the argument we just had?
No, Your Honor, I did not.
Well, I asked, they also were making an argument that something was shown to the jury that shouldn't have been shown to the jury, and that the motion for mistrial that was associated with that should have been granted. The judge abused his discretion in not granting it because it was an extremely prejudicial occurrence. The judge had given a curative instruction at the time, which is what happened here. We had we had an instruction to disregard, right?
Right.
And I asked the question, can you cite a case from either this court or the SJC? And I'm going to ask you the same question, where when a jury has been instructed to disregard evidence, court has nevertheless found that there was so much prejudice from the error that that a mistrial had to have been called.
I don't know. I don't have a case, Your Honor, on that point, but I just go back and say again that
because we have this,
Yep.
we have this law that says we presume that juries follow instructions. There's good reason for the rule, right?
Yeah, I mean, I thought of that, you know, before this argument. I said, well, so you know, it's the law. You know, you have to assume that the jury will heed a curative instruction or a limited instruction. But I think if you read DiMaggio, I think as a practical matter, and I know it's not the law, but as a practical matter, I think we can all be skeptical as to whether a jury heeds a curative instruction. And I know it sounds ridiculous because it's not the law. I'm just arguing.
Doesn't sound ridiculous at all.
Yeah,
I mean,
so,
you've even had some pretty smart judges who, you know, sat on courts like the U.S. Supreme Court who said things like, you can't possibly believe that a jury can heed the instruction that was given to them under those circumstances.
Yeah. So, I mean, I think it's especially prejudicial, especially harmful when the case is so close, when the Commonwealth's case is so weak that, you know, here a defendant is charged. He's indicted on 3 counts of sexual abuse of a minor. So, you know, the fact that he's in court, well, geez, you know, I mean, he must have done something. So then I think that, I mean, again, I'm off the top of my head, and forgive me, but I know what the law is, but it is a practical matter. It might not take anything more than a statement like that the jury can't unhear that would shift the balance in a case like this.
if we were to accept the kind of argument that this is a fairly straightforward instruction, by the way. This is not the kind of limiting instruction that that caused the statement that I was just referring to by Justice Jackson. But there's an immediate statement, disregard the comment by the witness. And your argument would have us overturning a lot of convictions if that kind of instruction could be determined to not have been heeded.
Yeah, and yes, I agree with you, Your Honor. It makes it even more difficult that, if you put yourself in a jury room during deliberation and a juror says, well, did you hear that statement? So the rest of the panel says, well, wait a minute. The judge told you to disregard that. So I understand that. So, in jury deliberations, that comment can't not come up as, well, proof that, he's done something bad before. I understand that, but and I don't know how to really, enhance my argument here, because I'm saying the same thing. I don't know how you can't help but think that from that statement, it planted some kind of thought in the jurors' minds that, this guy, he's got to be guilty of something because of that statement. But, my argument isn't making sense, and I apologize. I just keep saying the same thing.
No apology needed, sir.
Well, Your Honor, I have nothing further unless you have any further questions.
No, thank you. It's a single
Thank
issue.
you, Your Honor.
Thank you very much for your argument. Now we'll hear from the Commonwealth. ADA Jordan, the floor is yours.
Good morning. May it please the court, Darcy Jordan on behalf of the Commonwealth, and I would like to acknowledge the trial prosecutor, Audrey Mark, is listening via the live stream. The Commonwealth is asking you to affirm this conviction. This is one conviction, and I think, if anything, the conviction shows that the jury indeed heeded Judge Locke's instruction to disregard the evidence in this case regarding the statement by the witness referring to a previous problem. Therefore, basically, there's no inclination that the jury convicted this defendant based on some other previous problem besides the evidence that was before them. The statement itself just was really obtuse. It said previous problems. It really didn't go into any kind of detail. I had no reflection about even the testimony that came before it. There's definitely was no mention of previous abuse. Justice Engler, you asked whether or not the prosecutor is aware of any other kind of previous abuse. Off the record, not in the trial transcript, the trial prosecutor did inform me that there were some other allegations against this defendant. However, none of that came to light either in pretrial motions or in the trial. So,
except for the statement by the witness. Well, yes, about the previous problems.
And
I mean, if the prosecutor knew there'd been previous problems, that question never should have been asked.
Well,
agreed?
Well, yeah, I agree, but I think what the prosecutor is actually trying to demonstrate and harness is that there was no other problems with the defendant reported by the victim or the victim's brother, that there was any other kind of abuse. If anything, it was that this defendant was very friendly, took them to the frog pond, took them to get candy, meaning that the prosecutor is isolating it to this one issue of abuse because that was relative to the defendant's statement himself. Because later when there's a statement that the defendant said, oh, is this about the pillows? And I think the prosecutor was trying to harness the meaningfulness of his statement about this is about the pillows, because no one had, the police or the victim's mother had said anything about the pillows, meaning that defendant himself had basically an inkling that he knew that the victim was reporting about this abuse when it happened with the pillows. So I think the prosecutor's question wasn't meant to elicit any improper evidence, but was to really highlight the isolated incident in this case vis-a-vis the other corroborating evidence.
Don't you think it's a dangerous question to ask a civilian? No issues that you knew of. I mean, could have said nothing about the babysitting, but there is the freebasing of cocaine. I mean, almost anything can happen from that question.
Of course, and I think in the course of a trial, these are human beings live in the moment. Obviously, your honors are very aware how things can go either sideways or wrong or kind of hit the line during trial. And I think in this case, the prosecutor's statement really was to elicit, as I said, that other kind of, I think she was trying to get to corroborating evidence, not necessarily improper evidence. And I think the statement itself, as Justice Ditkoff alluded to other kind of options, and it just said babysitting problems. I mean, if we're going to speculate and ruminate, it could be that he was untimely, that he was late often could be a problem. It could be that he gave them food that they're allergic to or candy when he wasn't supposed to. So I think that Judge Locke's instruction to just disregard it was curative. And I think when we look at really what a mistrial is, the standard is it's at a trial judge's discretion, who has the ability to look at the evidence and read the demeanor of the witness as the jury is hearing that evidence. And it has to manifest necessity. And based on other cases, I think I cited to a case in my brief that talks about somebody had testified, oh, like he did this before, and there was a curative instruction immediately, and that remedied that prejudice. And I think this statement, as obtuse and vague and nondescript as it was, doesn't even come close to that statement, which was appropriately cured. And the other kind of assessment we have to look at is, what is the prejudice to the defendant? And as my brother kind of speculates, the jury could have thought this, the jury could have thought that. However, they're instructed to exactly do that and disregard it. And as Justice Engler discussed, sure, there are some instances where it is hard to unring that bell, and this is just not an example of the type of testimony that would be hard to unring, in that it really wasn't much of anything. It was prior problems, very, very vague, and not isolated to any other previous testimony or testimony in the future that was given, and it wasn't highlighted by the prosecutor. It was kind of a one and done and over. And even the motion for a mistrial is about 3 sentences, meaning that even in the course of the trial, the defense counsel was aware that, although of course in his duty for his client to make such a motion, but it wasn't pressured, in that Judge Locke said, well, I immediately and promptly instructed them, and even trial counsel was like, indeed you did. So it is clear to the Commonwealth that this remedy of a curative immediate instruction, allowing for the defendant to have a chance and opportunity to be heard, definitely was not an abuse of Judge Locke's discretion.
A lot of people would be reluctant to argue with Judge Locke, I think.
Yes, as a formal trial prosecutor, I have been in that position. So if we can turn to the sufficiency of the evidence, I think my brother is arguing basically that there's no corroborating evidence in this case to sustain the conviction. And in these kind of cases, corroboration doesn't always mean forensics or DNA. Corroboration can be corroboration of circumstantial things, other kind of statements made by the victim, and other kinds of evidence that, as we would say, are little bricks in the wall that eventually allow the Commonwealth to meet its burden. And unfortunately, in this case, the only witnesses to this crime were the defendant and the victim. And here the testimony in and of itself of the victim sustained the Commonwealth's burden in the light most favorable of the Commonwealth.
All right.
And as you point out, there was some corroboration in the statement by the defendant.
Yes, there was a statement by the defendant, because the incident started with a pillow fight with the victim and the defendant, and later on, the police are involved and say to the defendant, just leave this victim alone, don't go near him. There was no discussion about the underlying allegations. And also the victim's mother testified that when she confronted to the defendant, she made no reference again to this pillow fight or any specifics. But later, when the police officers are saying, like, don't go near him, he says, oh, this must be about the pillow fight. So his self his self-identifying statement corroborates the victim's account of the crime as well. And then we also have the victim makes a statement to his brother as well that corroborates. So these are the kind of cases that are difficult, but at the end of the day, those credibility assessments are for the jury to determine, not later dissections of whether or not my brother thinks the evidence should have been more.
All right. Unless there are any questions from my colleagues. Thank you very much. Thank you both. It's an interesting case and it's very helpful.
We are live and recording.
Thank you. I'll call the third case today, Commonwealth versus a juvenile, number 20P372. I'll remind the parties that this is a impounded case. We're not going to use any names of the juvenile, juvenile's family, or the witness. Instead, we'll use words like juvenile, juvenile's mother, witness, victim, complainant, however you want to call that person. This is a Commonwealth appeal, so we'll hear first from ADA Burbine. You have the floor.
Thank you, Your Honor. May it please the court, Carolyn Burbine for the Commonwealth. This is our appeal from the juvenile court judge's finding at the Chapter 119, Section 72A transfer hearing that PC did not exist. It's our position that the judge's finding was erroneous and that we did present enough evidence to show probable cause to believe the juvenile committed the one count of rape of a child with force or a lesser included. The case law tells us the minimum quantum of evidence required to find PC is analogous to a judge's ruling on a motion for a directed verdict at trial. And the directed verdict.
What tells us that for 72A hearing?
Matthews, Commonwealth versus Matthews, quoting Commonwealth versus Myers. And the directed verdict rule tells us that the judge should view the proceeding as if it were a trial and find probable cause if the Commonwealth presented sufficient evidence to send the case to the jury.
No.
Matthews
preceded the amendment in 1996. Matthews was under the 1975 statute, where the statute specifically said that it involved the standards of 119, Section 61. Isn't that correct?
Yes, but when there are later cases, for example, Davis, which came out in 2002, which was a juvenile case, which is similar language. And then also, I'd have to check the date, just 1 second. And then Commonwealth versus a juvenile, 413 Mass 148, 1992 uses that language. So I would argue that still applies even though the statute changed, and that Lattimore should be the standard.
Wait.
I'm sorry.
This is the heart of the problem, right? To me, you just flipped from quote unquote directed verdict standard that we have seen described in the case law to Commonwealth against Lattimore, which is our appellate standard for whether or not we affirm a jury verdict, right?
Well, what my argument is that
you have a case that equates the quote unquote directed verdict standard that we find in the case law and that you trace back to Myers with Lattimore?
I would say Mary cites Lattimore for this proposition, and that I also relied on the Blitzman and King.
Mary is 453 Mass, right? And what was the issue in Mary?
Mary was a vehicular homicide case, double jeopardy, and it discusses if we're talking about motion for directed at trial. It's supposed to be analogous to motion for a directed verdict at trial. The directed verdict rule says the judge should view the proceedings as if it were a trial and find probable cause if the Commonwealth presented sufficient evidence to send the case to a jury.
But that's just
And
not
evidence-
what Myers says, is it, counsel? I
It is,
Myers-
and then if,
sorry, counsel.
I'm sorry, Mary, that's what Mary,
That's what Mary says. You think.
Matthew says that, Mary says that.
But how did we? When did the rules get changed?
I don't think they did. I think when you look at what
Wait a
evidence
second, let me
is,
finish my question.
I'm sorry.
Myers says unequivocally that it is not sufficient merely to take what the prosecution says. It's unequivocal. It says that there's room for credibility determinations. And you are telling us the opposite. You are saying to us that if you put the evidence in, it's over. And the person making the probable cause, at least as to the probable cause issue, has no discretion. Isn't that your argument?
Well, I would point to footnote 12 in Myers. If you look at footnote 12 in Myers, it says that
I'm going to get it. I'm not running away. Sorry, go ahead.
That's okay. If you look at footnote 12, it says the only time that you would deviate from that premise, the credibility is for the jury, and the jury is not, and the judge is not supposed to resolve testimonial conflicts at a hearing is on the rare occasions when a witness's testimony is so weak or so contradicted by sufficiently clear facts that the judge should have that power. And that's not what happened here. So my argument is
not what happened here. How do we know
that's not what
that's
happened here.
exactly what happened here?
Her testimony was not weak, and it wasn't clearly contradicted sufficiently that you couldn't find PC. I disagree.
Counsel, do you agree that this is analogous to probable cause hearing in district court, a bind over probable cause hearing in district court?
The case law does support that, Your Honor. Yes. It talks that there are some of these cases that we're both relying on talk about bind over hearings, but I still think, I mean, we are PC in juvenile court for a transfer hearing. So, you know, for any of these cases to make sense, I think that, you know, if you're going to say it's the directed verdict rule, you view it as if the proceeding were a trial and find PC if we present sufficient evidence to send the case to a jury. How do you find the evidence is sufficient to reach a jury? You do that motion for required findings analysis, and that's like most favorable to the Commonwealth. And that's how it all ties together. And that's how we get from Matthews and Myers and Matthews and Ortiz to Mary and Lattimore.
You think that hearsay evidence is admissible?
No, I do not.
So you don't think any of your colleagues are doing 72A hearings?
I'm sorry?
You don't think any of your colleagues are doing 72A hearings in the juvenile court using police reports and testimony?
I'm sorry, I may have to back up on that. I have never practiced in the juvenile court, so I'm not certain about that, Your Honor. But I think that we didn't have a situation here where you would deviate from the premise that it's not open to. I'm sorry. Did you have a question? Oh, okay. I would just say I don't think it's open to a judge at a transfer hearing to weigh credibility in the way that a jury would. And I think in the light most favorable to, the question has to be, could any reasonable juror find in the light most favorable to the Commonwealth that the elements of the crime were satisfied based on the evidence? And here, the victim on direct and cross, she unequivocally testified the juvenile had sexually abused her. She, and that requires crediting her testimony, unless, like in footnote 12, she's so weak or she's so contradicted that the judge would have to, find her not credible. And I don't see that here.
But so you allow for the possibility that a judge has the discretion to judge credibility in a probable cause hearing of this type.
as footnote 12 in Myers says, on the rare occasion where I mean, if you have someone come in and it's a completely crazy story and it doesn't hold together and nothing makes sense, then yes, but that is not what happened here. I mean, we had an 18-year-old, she's 18 by the time she testifies. She unequivocally testified that he sexually assaulted her. She was, candid in her answers. You don't have any evidence of any motivation for revenge. She didn't come forward on her own. There's no indication of a grudge. She only came forward because the aunt found the text and confronted her. It would not be unusual to have some inconsistencies where it happened when she was 11 or 12 years old.
So this is an argument, but the argument you're making now is one that is not based on a Lattimore standard. The argument you're making now is one that says on the record before the judge abused his discretion or her discretion, I can't recall, in finding no probable cause based on this witness's testimony and the evidence that was before.
Well, I'm just now trying to refute some of the defense's attacks on her credibility by saying she's weak and contradicted by the clear facts. But it is, I'm sorry if I wasn't clear, but it's our argument that the judge, viewing the light most favorable to the Commonwealth, should have credited her testimony. She was candid. She was sincere. She's 18. She knew how old she was. She was able to relay all of the events.
See, you're now when you make that argument, you're in the precise opposite position that the Commonwealth is almost always in a sufficiency of the evidence context, where you would stand up and say, it's not the province of an appellate court to make some kind of conclusion on a cold record as to the credibility of the evidence. That's the province of the judge who sees the witnesses. And so it seems to me that that's your problem. If the judge has discretion, and I'm looking at Blanchett now, written by Justice Lenk, right? I mean, again, not exactly in this context. And maybe there's a difference because of the statute we're dealing with, but he makes it absolutely crystal clear that there's a ability of the judge to evaluate credibility in a probable cause hearing context, right?
Well, is Blanchett the sexual dangerous person?
Yes.
Case? Yes. I would argue that that's it's kind of a unique animal, but
Except that she's relying on Myers to describe what the standard is.
But Myers itself say that, let me see, I'm looking at Myers at page 850. The judge views the case as if it were a trial and he were required to rule on whether there's enough credible evidence to send the case to the jury. Thus, the magistrate should dismiss the complaint when, on the evidence presented, a trial court would be bound to acquit as a matter of law. So here we're dealing with the issue of credibility to some extent, but the dismissal is when a trial court would be bound to acquit as a matter of law.
Well, it just, again, I just based on that footnote in Myers, I realize we can't say that the judge can't make any credibility determination at all. But again, but that would be on rare occasions, as it says. So, and I think that's even true with Lattimore. I mean, the judge has to assess the evidence. Would it permit a rational jury to find the elements of the crime? If it's so weak, the answer to that would be no. But that doesn't mean that Lattimore wouldn't be the standard here. If the directive of verdict rule says you're supposed to view it as if it were a trial, how does that happen at a trial? It's Lattimore, and that's the argument. So could a reasonable juror find in the light most favorable to the Commonwealth that the elements of the crime are satisfied here? And our argument is yes, based on her testimony, where she unequivocally testified on direct and on cross that the juvenile had sexually abused her.
The judge can consider the credibility of the complainant when the judge goes on to the second step, the public interest step.
I'm sorry, I missed that, Your Honor.
When the judge goes on to the second step, the interest of the public,
Yes.
can the judge consider that the credibility, the judge's determination, the credibility of the complainant?
I think I hadn't actually thought about that, the second part where we weren't there yet. So in the second part, he is considering the public interest, safety of the public. I don't know the answer to that question, Your Honor.
Am I right in thinking the judge here was bifurcating the process, was going to do probable cause first and then later do the public interest, or is this all one hearing? Is this the evidence on public interest as well?
I do not know the answer to that. I assumed that if she had found probable cause, they would have moved on, but I don't know that was actually stated during the proceeding.
So we don't know whether, I'm sorry, Judge Ditkoff, did you have a follow-up?
Oh, please, Judge Engler.
So looking at 72A and the question that Judge Ditkoff just asked you, the language is awkward, right? Shall determine whether there's probable cause to believe said person committed the offense charged. That's the standard under which this was dismissed. And shall, in its discretion, either order that the person be discharged if satisfied that such discharge is consistent with the protection of the public. So
yeah,
the opportunity for the judge to say, in reviewing the evidence that's put before him or her, I have serious doubts about this case from an objective point of view, and I don't think it should go forward. Shouldn't that be part of the statutory scheme?
well, I'm not sure I understand the question, Your Honor. I know that here the judge said that she did not find PC and that as a result, the case was dismissed.
Right, and you say essentially, if I could, counsel, that was error because it should be, the probable cause inquiry should be a mechanistic inquiry. If there's sufficient evidence under the Lattimore standard, the judge was required to find probable cause, had no discretion. And my question is, if the judge listens to that evidence and says, this case, in my view, should not go forward, where is the room in the statute for the judge to do that? If it's not in the probable cause standard, is it in the second part of the standard that I just read to you?
Well,
or is it the position of the Commonwealth that the judge can't do that? Because see, that's where I get stuck. Because I thought that probable cause from the moment that it was written into the Constitution and the warrant requirement meant that you interposed a neutral between the government and the people and allowed that neutral enough discretion to cut things off. And you're suggesting to me that the neutral here doesn't have it for the probable cause part of the standard in the statute, that the neutral is required to find probable cause if the Commonwealth puts certain evidence in front of them.
and then the next step comes in. Then she moves on to the second stage, and then she decides whether the public interest requires, so I'm not saying it's a done deal that if she finds probable cause, she then has to find that the interest of the public require that the person be tried. That's the second stage. It's separate, it's independent. You move on, and then everyone puts on their case in terms of the second prong. I'm not saying that the first prong, if you find PC, you have to find that the public interest requires.
Well, But the
I'm
question
not
Judge
saying that
Ditkoff,
they're-
I understand. The question Judge Ditkoff asked you, and I understood you to say that you hadn't really formulated an answer, is whether or not in exercising the judgment about the public interest, you can consider the objective strength of the Commonwealth's case, which would include a judgment about the credibility of the witness.
I don't want to concede something that's error, but I don't know the answer. I mean, I suppose if you put your case on, I mean, you do get the opportunity to put your case on in the second prong, and everything should be considered. So I suppose credibility would have to be considered again. But that would perhaps not be the Lattimore standard. I'm not sure. I'd have to think about that.
Counsel, I want to get a little clarity as to your answer about whether this must be done in 2 steps, whether in fact that's what was going on here, or whether it can be, instead of the 2 parts, it can be done as one proceeding. In other words, if let's say the judge looks at all of this and finds that without even saying anything about probable cause, even if there were probable cause, it would not be in the interest of justice to allow the case to proceed. Could that be done all in one proceeding?
I think you have to do the 2 prongs. I'm trying to think what JH versus the Commonwealth said, because that was a case where the prosecution had not prevailed on the higher crime, but the judge found a lesser. And they said that the case should be remanded for the judge to give defense counsel an opportunity to put on his entire case on the lesser included. I don't know if that sheds any light on how this should work.
But in any event, in this case, you're saying that the judge's statement on the record was as to probable cause itself.
Well, it was, she said it was probable cause, and she said it's dismissed, we're done. And that's it. And she didn't make any, she didn't elaborate on her reasoning or anything
So
like
on
that,
this
no written
record-
findings.
On this record, you're saying it appears that the decision was purely on probable cause and that she never got to the second consideration.
Yes, because trying to, let me see if I can find her wording.
I've got it in front of me. I've thought about this. I do not find probable cause complaint or any of the lesser included. The matter is dismissed. That's the only thing she said, right?
Right, the matter, and they said the matter is yes, the matter is dismissed.
I'm sorry, if I could, can you indulge me, guys, for 2 more questions? Is there anything in the record that tells us the age of the boy, the defendant, at the time that this occurred?
The victim said she was 11 or 12, and she said that he was 2 to 4 years older and that he was on the high school football team.
But that's it. So nobody put
That's-
in his date of birth?
No, not that I recall, Your Honor. I don't recall anyone doing that. But that was what her testimony was.
I mean,
As to age.
and do you agree with your sister that the Commonwealth did not suggest statutory rape as a lesser included to the judge?
Yes, the ADA asked the judge to consider the lesser included of indecent A and B and A and B. He did not specifically ask for statutory rape.
Can a 14-year-old be guilty of statutory rape in the Commonwealth of an 11-year-old?
I do not know the answer to that question. I believe the defense counsel also in his closing might have said that the defendant was 15. And I'm not positive. I just remembered that, but I would have to check. Yeah, she said 2 to 4 years older and on the high school football team. So high school, you would assume freshman would be 14 at least.
Right. That's
Right.
why I asked the question posing
Right.
the number 14.
Okay.
Plus, it happens to be 2 years older than.
But 4 years older would be 16, 15 or 16. So,
Right, but it's your burden, right?
No, I understand, Your Honor. I understand.
Right, Judge Ingley?
Did the court have any further questions?
Uh.
Thank you.
All right. Thank you very much. You get to do this twice more over the next few weeks. But we only have to do it once. We'll now hear from counsel for the juvenile, Attorney Cuthbert. The floor is yours.
Thank you. Good morning, Your Honors. May it please the court, I am Mary Ellen Cuthbert and I represent the juvenile appellee in this matter. And listening to the argument, I do agree that in this particular case, under 72A probable cause hearing, it is the Myers standard that controls. It is simply the judge's decision, and the court leaves the resolution of the credibility issue to the hearing judge, because that is the judge that heard the live witness. And our mass case law has stated that the credibility and the finding with regards to credibility is on the hearing judge.
Let me ask you, what do you say about the quote in Myers, where they indicate that the magistrate should dismiss the complaint when on the evidence presented, a trial court would be bound to acquit as a matter of law. Would you say that on this record, that a trial court would be bound to dismiss or to acquit?
I believe we're referring to note 12, which follows in Myers the statement that the defense may, from cross-examination and eliciting other evidence, may lead the examining magistrate to disbelieve the prosecuting witness and discharge the defendant for lack of probable cause. I have gone through Myers, which is the standard here, very thoroughly. Myers lists no less than 9 times talking about sufficient credible evidence, talking about minimum quantity evidence, quality of the evidence, talking about witness credibility in determining probable cause.
Can I ask you this? Do you agree that it is a similar standard to a district court bind over hearing, where you have a similar procedure, right? There's the issue of probable cause has to be found, yet defense has the right to cross-examination. There's live witnesses. All elements have to be made. Do you agree to that standard?
There is, but I also note that Myers and some of the other case laws say it is somewhat analogous to a district court bind over hearing. But with regards to every bind over hearing where the judge is makes the determination as to credibility and the sufficiency of evidence. This is not the Commonwealth versus Mary or Commonwealth versus Lattimore cases where those were adult jury trials, where the jury was the final arbiter of credibility and whether there was sufficient evidence.
But the probable cause determination is always the judge in both of those proceedings, right? So it's analogous to that extent.
That's correct.
Ultimately, someone else is going to be the fact finder
in a jury trial, but it is the judge in a probable cause or a 72A hearing that becomes a fact finder, because there's no jury.
But that's only to see whether you eventually get to a jury, right?
Right, but this is not whether we get to the jury. This is whether this juvenile should be transferred from the juvenile court proceedings to an adult. In this case, it would be Superior Court and face adult state prison sentence.
And likewise, in a district court probable cause hearing, the issue is whether it gets transferred to another venue, right? So it's analogous to that extent. I'm trying to figure out whether we can use those cases that discuss district court probable cause, those determinations, to the extent credibility is looked at there, whether we can use it in this context as well. And why wouldn't we?
To some extent, but I would also point out Commonwealth versus Jamal Davis case, which talks specifically about 72A hearings, where not only did it indicate that the judge does not have to make written findings, but it also said the judge does not need clear and convincing evidence. It only needs record support to make a determination with regards to how the judge rules in a 72A hearing. And in this particular case, there is record support for her decision to find no probable cause. As I point out in my brief, and I would argue now, there is certainly questionable evidence presented by the Commonwealth through their sole witness, which is whose testimony is totally uncorroborated. There's not one piece of evidence document.
You may say that it's uncorroborated, but how is it questionable? What is the overwhelming evidence such that you could not possibly believe this witness's testimony?
There is significant evidence where she varies in her story, but it also doesn't have to be overwhelming evidence not to believe. It's simply there just has to be some evidence which would draw a question for the judge. In this particular case, there's differing and varying stories about penetration, not penetration, depending upon who's asking.
Well, that can't be the standard either. Some evidence that draws a question for the judge, that can't be the standard either. I mean, we're in the world of probable cause. Probable cause is less than it's less than a preponderance of the evidence, let alone at least in my understanding. Now, Judge Singh's questions really go to a very good point, which is, what probable cause are we talking about here, right? We have probable cause in the Fourth Amendment context, and that has a set of rules around it, and we regularly overturn judges' determinations that there was a lack of probable cause in the Fourth Amendment context. We do it all the time, okay? And then you have probable cause under Myers, and maybe that's the same thing as probable cause that's talked about in Commonwealth against Perkins, and maybe it's not, this directed verdict standard. And Judge Singh is trying to pin you down as to what is the probable cause standard in the context of the judge taking testimony to make a determination as to whether a criminal case should go forward. And I hear you suggesting maybe it's some other standard, and I don't know why we would do that. Why do we want three different probable cause standards?
I apologize. I think that it's very clear from my reading of the case law that Myers is the probable cause standards, and Myers talks about the credibility of the witness. And then it is the credibility of the witness, and this judge is the one who saw the witness, heard the witness, and is entitled and is mandated to make that determination as to credibility. And it is apparent that she did so. The Commonwealth's argument at the end of the hearing rested on credibility. And argued.
Surely the judge's determination is not without review. I mean, if the evidence were overwhelming that the case should have gone forward, the fact that the judge has decided to dismiss it can't be sort of rubber stamped on the notion that it was a credibility determination, right?
I understand there is some case law that does say that it is the hearing judge that makes that determination, and a reviewing judge at a reviewing court can't review that. However, in this particular case, I would suggest that the evidence was not overwhelming. There was no corroboration, there was no report. The circumstances under which she made the allegation, where she was in trouble because she had been found with a phone that she was not supposed to have. Other factors where there were people present in the apartment where the allegation supposedly happened, including a person that was 1 to 2 feet away, that she never reported it to the police or to DCF social workers and a therapist that she had at the time and going forward. And these were people who she indicated and testified cared about her well-being. And then there were changing stories.
Counsel, this is typical fare for any sexual assault case. It seems to me a dangerous proposition that when we look at the transcript, I'm looking for something from you as to when we talk about enough credible evidence, not simply that there are challenges. There's challenges. That's what cross-examination is for. There's challenges to people's credibility in every circumstance. I mean, but I think the case law talks to something so significant where you would say that no sort of credible fact finder could possibly believe this witness's testimony in light of all of the countervailing considerations, things that completely undermine the testimony. That's not how I read this transcript. I'm thinking about there's real concerns when you have a transcript that makes out the elements of the case, if you credit the victim's testimony, and a judge being able to look at that through their own lens of perhaps prejudice, bias towards that person who happens to be in that victim chair, the witness chair, and being able to say, despite everything she's testified to, and the fact that, yes, people can try to challenge her credibility, I don't believe this person, this case is not going forward. Do you see the danger in allowing that judge to have that level of control over the credibility of that witness?
I understand what Your Honor is saying. However, I do believe this record supports that there are issues with her testimony and credibility about her testimony and the circumstances, how it came out. So the record supports, to some degree, record does support that this judge did not abuse her discretion in deciding that this was not credible evidence. That is the argument that the Commonwealth made down below, and they went through several things.
Was there anything in the evidence that indicated that this could not have happened? For example, that this person was not there at that time, that the juvenile was living elsewhere, that they didn't know each other at the time, anything of that nature?
Nothing was presented at this hearing, but I would suggest that there was no evidence to the opposite, Your Honor, that would have supported the Commonwealth's proposition that this was credible evidence, despite the fact that numerous people were listed during the time of the hearing, that there was evidence regarding phones and things like that. Nothing was presented to support this one witness that the Commonwealth put on, and it was their burden to show that there was sufficient credible evidence in this particular case for a 72A probable cause determination to be made by this judge. And then there were the undermining factors that drew against her credibility, such as the time of the report and the circumstances of the report.
Counselor, before 1975, there was no probable cause requirement in 72A at all. Between 75 and 96, the statute specifically said that it was governed by 61, which was understood to require a directed verdict standard. But in 76, the legislature deleted that requirement. So I asked your friend, and she couldn't give me a single case saying that it's a directed verdict standard that involved the 96 statute. Do you have one?
I would suggest a Commonwealth versus Jamal Davis case, Your Honor.
That was a 1990 murder. So that wouldn't have been the 96 statute, even though
that this was a 2002 case, and it specifically references 72A hearing, and it talks about.
What's the site on that, counsel? I'm sorry.
That is 56 Mass Appeals Court, 410, 2002.
There was a 1990 murder, so it would have applied the old statute.
And it talks about the differences between the old 61 and the evolution between the old 61, which was very specific about what the judges had to find in terms of deciding whether to transfer a juvenile. The 72A statute, which was decided afterwards, and it's assumed that the legislature knew what they were writing based on when they changed the statute, left it very open. The judge shall, after hearing, determine whether there's probable cause to believe that a person committed the offense and shall, in its discretion, either order the person discharged if satisfied that the discharge is consistent with the protection of the public. So the legislature completely changed from the old 61 statutes, 61A, and set a new standard. And this would also be in conformity, I would suggest, with Chapter 119 and the overarching feeling of the juvenile statutes. And as I indicate, the record, I believe, supports this judge's determination with regards to a question of credibility. And in fact, she is the one that saw the witness, and I would ask the court to uphold and affirm her decision with regards to there being a lack of probable cause.
Counsel, your time is up, but we went quite a bit over with your friend. So if you'd like to say some more, you certainly don't have to, but you certainly are entitled to some more time.
Thank you. I would just briefly state that, again, Myers states over and over again that it is the sufficiency and credibility of the evidence and the quality of the evidence. And the record supports that this judge who listened to the one witness did consider that. And at the end of the probable cause hearing, after the Commonwealth argued credibility, she indicated that she considered and thought about both the principal charge and the underlying charges, lesser included charges, and found no probable cause. I would suggest that the case law and the standards here require that because she is the one that saw it and there's no adequate alternative to this judge seeing the witness, that unfortunately the reviewing court has, that her findings with regards to credibility and probable cause should be upheld, and I would ask the court to do so. If the court doesn't have any other questions, I will rest on my brief.
All right. Attorney Cuthbert, you've had a storied career as a litigator, but I don't think you've ever been before us before. Is that correct?
Once years ago on a 211-3, but that's correct.
Well, we are very happy to finally have the pleasure of having you in front of us, and I hope it won't be another 30 years before the next time.
Thank you for mentioning the number of years, Your Honor. I look forward to another time.
Thank you both. This is a really interesting case. So we know there's two other panels hearing similar issues, and we'll try to coordinate with them. But really fascinating case, and this was extremely helpful. And so.
And we are live and recording.
Thank you very much. I'll call the fourth case today, Department of Children and Families versus Mother, number 20P704. Before I start, Attorney Lynn, Attorney Grammel, who's going first? Who's going second and third?
I will be going first, Your Honor, for DCF, appellee DCF, and Mr. Grammel and I have agreed to split the time evenly.
Wonderful. All right. I'll remind everyone this case is an impounded case. We will not be using the names of any of the family members. We'll instead say the child, the mother, the father. You can certainly use the names of the doctors, but not of any of the family members involved here. We'll start with counsel for the mother, Attorney Curtis. The floor is yours.
Okay, great. Thank you. Robert Curtis for the mother, appellant mother in this case. Mother presents four individual and what we consider meritorious appellate issues in this case, highlighting various errors made below. And DCF and the child, viewing each in isolation, seem to suggest that each of these errors, none of them were prejudicial. But Mother contends that the court should really look at the totality of all of these issues through the entire case to determine whether the result was both fair and legally sound. In the aggregate, Mother didn't have a fair opportunity to mount her defense, and the evidence that was properly offered against her doesn't clearly and convincingly prove her unfitness. So the first issue Mother raised in her brief relates to the expert opinion evidence from Dr. Velez. And I'm just going to call her Dr. Velez, frankly, because I probably won't be able to pronounce her full name throughout the entire argument. So I think there's no question based on the record that Dr. Velez was not qualified as an expert witness. Therefore, any expert opinion evidence from her should not have been accepted or relied upon by the judge. Now, within the record, the judge does in fact rely on some of this expert evidence. In particular, there was one passage where Dr. Velez stated that it would take mother 4 to 5 years of work before she could be able to resume parenting capabilities for the child. And that made it into the findings. So the extent to which the judge relied on it.
Did it make it into the findings, or was it merely a summary of what she had said?
Well, I mean, I suppose that's up for debate, but it's in the document. It's in the findings document that she said this. So what we don't know is the extent to which the judge relied upon it. But, you know, that sort of leads into the next issue, however, is that either the judge had to have relied on it to issue the judgment that she did, or she didn't have any expert evidence whatsoever to support her finding, because, you know, as Mother argues in her brief, the Jameson case, it really suggests that when you're dealing with issues involving a party's mental health and the effects of that mental health on, you know, parenting abilities or things of that nature, those are proper subjects, and you actually need to have some sort of expert evidence.
There was an expert, your social worker testified that she needs therapy to be an effective parent.
She needs therapy, right? But so that's not the same as suggesting that you know, mother. I mean, in mother, there's evidence in the record that mother was doing therapy as well. So I mean, the fact that she needs therapy isn't quite the same as suggesting that she's unfit. So, you know.
Well, wait a second. So I think we're dancing around a little bit. There's evidence that she was in therapy, which the judge essentially found to be inadequate. I mean, as I read the judge's findings, it was she did some therapy for a certain period and I'm going to get my years wrong, the end of 2017. At which point she then moved, she stopped, she moved to New Hampshire, she tried again, she was terminated because she wasn't showing up. And the judge said, I think there's a finding in here that, you know, she's not doing therapy, she's not following through with her service tasks, her plan. And as a result, you know, that's part of the reason why she's unfit. Am I misreading the findings?
No, I mean, I think that's correct. That's what the judge did find. And, you know, we don't argue that those are clearly erroneous findings, although, I mean, I think arguments can be made to question them, but that's not really the issue we're making here. So that is in there. However, that alone doesn't, I don't think there's enough of a nexus there between mother not going to therapy and her unfitness. And that's really the problem here. So yeah, those findings were in there, but there's not enough there to connect that to her unfitness. And I think Jameson really does say when you're, I mean, I know Jameson, the facts were a little bit different. They were talking about the mental health issues of the children in that case, but the SJC makes it pretty clear that when you're dealing with those kinds of issues and the consequences of how mental health affects, you know, these issues, you need to have some sort of expert evidence, and then you need to have that nexus between the issue and.
Why isn't a social worker testifying that she needs therapy to be an effective parent enough to show a nexus between her mental health problems and her parenting?
Well, I think a nexus requires more than that. I mean, why does the lack of therapy make mother unfit? I mean, there's no dispute that mother, you know, needs to do therapy. I mean, I don't think we're arguing that, but you need more of a connection between.
Oh, she needs to do therapy for at least two reasons. One, she has severe anger problems, which cause her to be unable to have any stability in terms of her relationships. Her relationships fall apart for her over time because of her anger problems. And related to that is she accordingly is found to have no consistent or stable housing, right? And that's tied, isn't that tied to her need for therapy?
It may be to some extent, but I don't know that loose of a tie is enough of what we need here when we're looking at a standard that's clear and convincing evidence to show not only that, you know, the mental health issues may be tied to, you know, her housing situation, but the harm, the significant harm to the child. And again, I think we're talking about loose ties here, but we're supposed to be at a clear and convincing evidence standard. And I think we need a little bit more than that. And really it's, you know, what we have here in the record, even to the extent that it's a social worker, there's nothing directly connecting these two things. And I mean, when you look at the other evidence that really the judge virtually ignored, but we highlight in our brief, when the child was with mother, for the most part, things were going fine. The one event that led to the child being removed from mother was when mother was placed at a congregate shelter where she never should have been. And that connects to the reasonable efforts argument. Mother never should have been there. She was doing a good job parenting this child when she was in an appropriate placement and she was working on her issues. But then she gets moved to this congregate placement where there was evidence in the record that she should have never been placed there. So DCF set that up well, I shouldn't say DCF entirely, but by not ensuring that she was able to stay in an appropriate placement, DCF didn't make reasonable efforts at that point. And from that point forward, you know, the ball started rolling down the hill, but
I couldn't find any place in the record, and I read the closing argument pretty carefully, where your predecessor argued anything about reasonable efforts. Did I miss it?
No, so I mean, if the issue is, if the question really goes to whether the issue is preserved, I say it is, because reasonable efforts is required. You don't have to, a party doesn't have to request a reasonable efforts finding. Reasonable efforts is you know, DCF has the burden of establishing they made reasonable efforts, and the judge has to make the finding. So it really wasn't on the mother to, you know, raise this.
But it's it's on somebody to make an objection that you haven't made that finding, isn't it? As opposed to just sort of bringing it up on appeal.
I'm not sure that's the case where the burden is on the other party. DCF had to prove that they made reasonable efforts and the judge had to find it. Those two things weren't done. I don't know that there's an obligation.
What do you mean to prove it? I mean, isn't there case law that says even if you find no reasonable efforts, you can still terminate if the circumstances justify that?
Right, but then that has to be addressed in the findings, that there was no reasonable efforts, however, the circumstances justify it, and that wasn't done.
A form with the box checked that says reasonable efforts to unify made. And I understand it's not in the opinion, but maybe that's because no one gave any indication to the judge that it was a live issue. And she thought the form would be enough. Why isn't that right?
Well, I'm glad you brought that up, Your Honor, because after I filed my brief, I stumbled upon a case. It's not a child welfare case, and I apologize, I'm scrolling through my screen here to find it. I believe it's Nelson N. It came out in 2020, and it was a 209A case, but they talked about check the box findings when in situations where the law requires actual findings. And
citation?
Let me, again, I'm scrolling my screen here, but the case is called Nelson N versus Patsy P, 98, Mass Appellate Court, 78. And if you look at pages 81 to 82, the court says, check the box findings of the type used here may assist in satisfying the requirements of findings, but they must be completed or supplemented so as to constitute case-specific findings regarding key disputed issues. And then it goes on talking about the 209A issues, but it's the same situation here. It's analogous. It's not a 209A case, obviously, but in both of those cases, specific findings were required, and check the box isn't enough. Not only that, though, and I do reference this in my brief, permanency hearings, we don't frankly know what the standard is for the evidentiary standards, the burdens there. They're not necessarily the same as what the judge is required or, what's required at a trial on the merits. So the fact that there was a check the box finding at a permanency hearing doesn't necessarily mean it applies.
That's an argument that says you don't even have to argue to the judge they didn't comply with their statutory obligation. You don't even have to put it out there as an issue. You can just raise it on appeal. Hey, guess what? I pulled out a plum on appeal. There's no finding. I mean, in the civil context, that's pretty rare for us to do that. Frankly, in the criminal context, we do it for elements of the crime, and that's about it.
I don't know if I necessarily agree. I mean, even in purely civil cases, the plaintiff goes first. If they don't meet their burden,
you got to move for a directed verdict.
Right.
And you have to argue what was not proved.
Right, but
general rule.
Right. So you have to, but the decision still needs to be based on the plaintiff satisfying their burden. If the plaintiff doesn't satisfy their burden and the judge goes ahead and issues a judgment anyway, then I think.
And we're not going to reverse it unless there was a motion for a directed verdict, and the motion for directed verdict identified as a concern, the one that is then identified on appeal. Anyway, I'll take a look at what you say.
I mean, in these cases, though, I mean, they're not subject to the rules of procedure. There is no directed verdict rule in these cases. And, in some ways, these cases are similar to criminal. I mean, I think, my understanding is they're civil cases.
These cases aren't subject to the rules of procedure?
The rules of civil procedure don't apply to child welfare cases in the juvenile court. I mean, we use it as a cogent standard sometimes for certain situations, but
the rules of evidence apply to the trial?
The rules of evidence apply.
Okay. Because that seems to me is important to your argument about their expert witness.
In what way, Your Honor?
Your argument is that the expert witness report should not have come in. It's a violation of the evidentiary rules. Should not have been relied on because it should not have come in.
The opinion.
There are a lot of instances in which in other contexts, other processes that we deal with, we would allow that. But I took it, and the way I've always reviewed these cases is the rules of evidence apply to the trial.
They do, but the rules of evidence require, before any opinion evidence is taken in, that the expert be qualified. And
I agree. Couldn't agree with you more.
And there's no question the expert wasn't qualified here. I mean, there's nothing. There's not even a CV. There's no testimony. There's nothing.
Mm-hmm.
So that is the rules of evidence, and it does apply, and it should exclude that evidence for that reason.
Okay.
Could you just, could you address the issues of, sort of your issue regarding the last minute?
I'll do that here at the last minute of my argument, or the last 13 seconds of my argument. The timing certainly was not fair. In November, the decision was made to, switch from reunification to adoption. At that point, my brother, trial counsel, said, I'm going to need more time to do this trial. The judge says, no, this case has been out there long enough. But what we're going to do is we're going to set these disclosure deadlines. So you'll get everything you need a month and a half before trial, 6 weeks before trial, and you'll be able to prepare. Well, then DCF didn't make those disclosures on time. Mother was still receiving documents, witness lists within days of the start of trial. And all along throughout the process, in early February, Mother filed another motion saying, I need more time. At the motion hearing on the 20th, I believe it was, February 20th, Mother's counsel argued, I need more time. First day of trial, motion in limine, everywhere kept saying, this isn't fair. I didn't have enough time with this evidence. And I mean, in a case like this, where we're dealing with fundamental parental rights here, and the determination of parental rights, absolutely has a heightened due process.
So how can we prejudice? Your predecessor said that you got a lot of documents, but they were all adoption file documents that were new documents. And that's not really a big part of, or really any part of the findings here. Ultimately, the New Hampshire witnesses, when it turns out they don't show up, your predecessor doesn't say, well, a little more time, we can get them, or hold it open. So where's the prejudice from the lady?
I think when you're talking about prejudice in a situation like this, you're talking about an attorney's ability to look at what evidence is anticipated and being presented, and then strategizing how he's going to use this. And so I can't give you a roadmap of exactly how counsel was unable to do his job there, but I think it goes without saying, when you're still receiving documents, and these documents are being admitted despite the fact that there was an order for disclosure of these documents, and that order was flouted. You know, I mean, obviously, I think it goes without saying that counsel didn't have enough time to analyze these documents, develop a strategy. And I don't know if I entirely agree that he didn't preserve, you know, with regard to the New Hampshire documents, preserve, you know, his objection there. I mean, he at every stage said, you know, look, I don't have enough time here. He tried the letters rogatory, they didn't respond, and then we're in trial. So, I mean, he absolutely made an effort within the short amount of time he had to do something with this. And the New Hampshire documents didn't.
Can I ask, what is the actual technical argument you're making here? Is it that there was error in the refusal to continue the trial?
Yes, well, right, yes, I think so. I think at any one of those points in time.
Well, there has to be, what was the error that the judge committed?
It was a due process violation.
The judge had a trial, had witnesses, that seems to me to comport with most fundamental fairness. Everybody was present. What was the error? Is it there was a motion to continue and he should have continued the trial? Is that the error?
Yes, yes. I mean, especially the February motion. I mean, there was an oral motion in November. I think that sort of sets the stage, because trial counsel made it clear at that point that he wasn't going to have enough time. But then come February, when none of these disclosures were made in a timely manner, and he filed another motion, a paper motion to continue the trial, that should have been allowed. There should have been some additional time there. Due process requires that. I mean, yes, Your Honor, there was a trial, but was it a fair trial? Did mother's attorney have enough time with the evidence to determine a strategy? No. I mean, really, that's not the case. And remember, all of this happened within a 3-month span. The child was going to be reunified with mother, and suddenly everything changes. And you know, counsel had to scramble, and while he was trying to scramble, he was being thwarted because he wasn't getting disclosures in a timely manner.
All right.
Not fair.
Is there any further questions from the panel? All right, thank you very much.
Thank you.
We'll now hear from counsel for the department. Attorney Lynn, you have the floor.
Good morning. May it please the court, Stephanie Lynn on behalf of Appellee DCF. We're asking that the court affirm the trial court's order finding mother unfit and terminating her parental rights as to the child. You know, as of today, the child has been with her pre-adoptive family for 4 years. Her foster parent is also the adoptive parent to her biological sister, and she's doing well in that placement. And despite the trial court's numerous findings in support of its conclusion that mother is unfit, in this appeal, mother seeks to have the entire case remanded based on essentially arguments that the errors were made, and even if assuming for sake of argument that errors were made, and any of those errors did not prejudice mother to the extent that this case needs to be remanded. There was a lot of cumulative evidence in the record regarding mother's unfitness, and so any of these errors that he claims.
Well, the only expert testimony on behalf of the department, the only opinion evidence that I'm aware of, came from someone who wasn't qualified as an expert and didn't testify, right?
Dr. Velez Echeverria was not qualified as an expert and she did not testify. That is correct.
So that report should not have come in.
You know, counsel made the objection about her expert testimony at trial, and the court took that into account, considered that, and said she would give the report the proper weight.
No, no,
and I would argue that
see, that's the question. That goes back to the question whether the rules of evidence apply. Because if the rules of evidence apply, then the judge has to actually make a ruling. It's either in or it's not in. It's not in to whatever degree she decides that she wants to give some credit to it. That's not a ruling on an evidentiary issue. Do the rules of evidence apply?
The rules of evidence apply, yes, Your Honor.
Okay, so if the rules of evidence apply, she has to make a ruling. It's in or it's out. Since she quotes it in her findings, I'm assuming she admitted it. Am I wrong?
I think that we should assume that she admitted it because it was quoted in the findings.
And that was error, wasn't it? Because this person didn't testify and the report itself was hearsay. And since she wasn't qualified as an expert, no opinion testimony should have come in.
I think that the court took this report only as further cumulative evidence of what she already had, which is that it is undisputed that mother suffers from mental health issues and that she needs trauma-focused interventions. I think that
but the portion that was quoted was one of the most devastating things that, you know, you could view it as something that could change the entire 4 or 5 years for the mother to become competent in parenting. If a judge is looking at this opinion, credits this opinion, it would take 4 or 5 years before the mother could become a competent parent. That's too long to wait for this child, right?
I think that if the court took that into consideration, that is one finding. I think that there was plenty in the record to show that the mother was unlikely, for whatever amount of time, was unlikely to improve in this area. And we know this because she has a long history with the department, that these, you know, angry and emotional outbursts are part of her history. You know, when she was pregnant with her first child, she tried to attack someone with a knife. And then, you know, she, you know, even right up to trial in November, she, you know, had one of these violent outbursts in front of other children. And then with the child herself, she was holding the child in her arms as she was yelling, screaming, slamming doors, talking about burning the building down. You know, all of these things happened and are in the record. And the key thing that was in all 4 of the family action plans that DCF put forward for this family included, very importantly, consistent engagement in therapy and an acknowledgement of why this happened in the first place. And I think that those are key things for preventing or learning to de-escalate so that it doesn't happen again. And so this case was open for 2 years. She didn't make improvements in those areas. At no point, including at trial, could she acknowledge the reason.
So that's an argument that yeah, well, you didn't concede error, but let's say that's an error. That's an argument that says if there was error, it wasn't prejudicial given the entire context of the case.
I agree. Yes. And I think also that it shows that she was unlikely to improve, even if we don't attach any significance to the number, to the 4 or 5 years. The fact that right up until the end, she stated that she disagreed with the task of having to engage in therapy, that she didn't think that trauma-focused therapy was a thing, despite the fact that her own expert witness said that that was what she needed in order to parent. You know, that the court was right to find that she was unable to de-escalate and that she displayed a lack of insight about, you know, why this happened in the first place, and that you know, supports the finding that she is unlikely to improve in the future, since she's only doing therapy because she says it's on the action plan.
Counselor, we have a form dated May 24th, 2018, finding that DCF made reasonable efforts to reunify.
Yes.
But that's the end of that. So what do we have? What do we do with the fact there's no finding after May 24th, 2018 of reasonable efforts to reunify?
So there is a finding the latest finding was actually April 25th, 2019, which occurred a few weeks after trial, but before the order came out and before the findings of fact were filed.
There's no check on reasonable efforts to reunify or not to. Instead, they checked reasonable efforts to place the child in a timely manner with the foster home. But since the DCF has an obligation to make reasonable efforts to reunify, what do we do with the fact that between that whole 11 months, we've got no finding of reasonable efforts to reunify?
So I think that there were a lot of findings made by the trial court that show that the trial court considered this question, considered the efforts of the department, and could have made the determination that they were reasonable efforts. There were 4 family action plans, as I mentioned, covering 2 years that she wasn't able to make improvement on in those key areas. The department made a housing referral that was finding of fact 46. The department assisted with transportation in order to facilitate visits. That was finding of fact 55. The department assisted with not just 1, but 2 ICPC requests. And that was key because visitation we were trying to improve, we were trying to extend, and the next step would have been overnights. And we weren't able to take that next step. But after the first ICP request was denied, we assisted with asking for another one. And the court also was allowed to take into consideration mother's failure to achieve the tasks on her action plan, and really her refusal to even accept that the tasks on her action plan were going to make any help for her. So I think that there are enough findings in the record to show that the court did determine that these efforts were reasonable, and that mother rejected the department's help.
All right. Unless there's any questions from my colleagues. Well, thank you very much.
Thank you.
From counsel for the child, Attorney Grammel.
Good morning, Your Honors. And may it please the court, my name is Sean Grammel, and I represent the appellee child. She's asking that you affirm the trial court's decision that terminated her mother's rights and freed her for adoption. There are really 2 events here that bookended this case. The first was the removal in April 2017. Mom had this angry, explosive outburst in front of a child, my client. The police had to be called and she lost her housing. And then you can fast forward 1.5 years to November 2018. Mom had an angry, explosive outburst in front of children. The police had to be called and she lost her housing. And in between those 2 events, Mom failed to engage in consistent mental health services. Mom told her own expert that actually over the course of that time that her mental health had gotten worse. Her symptoms had actually been getting worse because of the removal and the constant conflict that she had living at maternal grandmother's house. And so there's really, her unmet mental health needs and her housing instability are 2 sides of the same coin. And the judge looking at that, looking at the facts here, not really looking at the diagnoses or the conditions, looking at the facts of what mother did, her behavior, and what she failed to do, not really engaging with the services that she needed. She didn't abuse her discretion in finding mother unfit. That's the standard here. It's not.
Oh, really? Abuse of discretion?
On appeal, yes.
It cannot be that the Constitution allows one judge discretion to terminate parental rights.
I'm sorry. On appeal, the standard is: did the judge abuse her discretion in finding clear and convincing evidence? Yes. And so I agree with Attorney Lynn that there was a lot of cumulative evidence here, and I think Mom's own experts, the experts, I would agree that the DCF evaluation, the judge was not very clear about what she was doing with that, and it kind of did sneak into the findings, but we can throw away finding 34. Just throw it away then. Mom's own experts testified about those same 2 issues, her unmet mental health needs and the housing. Dr. Kleiman said that Mom's historic homelessness and housing instability posed what he called a legitimate risk to my client.
You mean 34A and B, not all 34?
Yes, Your Honor. Yes, the findings.
Well, you say you can throw them away, and that's what's the word I'm looking for? That would be very fortunate if you could just throw them away. But as Judge Singh points out, some of the most powerful evidence in the case is going to take 4 to 5 years for mom in therapy to be able to do this.
I would disagree about the power of that evidence, because the judge in finding 34E said she didn't really care about the experts there. She was focusing on mom's behavior. And so looking at the behavior in November 2018, that's much more powerful than what any expert would say. And that's in adoption of Wilhelmina. This court said, especially considering mom's diagnoses, which are, there would be a wide range of behavior there. She has anxiety, depression, PTSD. There are lots of different ways that those diagnoses could manifest in behavior.
Did you represent the child at trial?
I'm sorry, Your Honor?
Did you represent the child at trial?
I did not.
How old was the child at the time of trial? 5?
3. She's 5 now.
5 now. Okay. Sorry, go ahead.
I lost my train of thought there.
All my fault. I apologize.
I would like to touch on the motion to continue piece here. I have worked in the trial court before, in juvenile court, and I've been given a stack of documents. I really wanted to agree with Attorney Curtis here, but there was just no prejudice to mom. There was nothing that would show that there was a patent abuse of discretion when the trial judge said, no, this case is 2 years old. The child is 3. She needs some permanency here. There's a line in mom's brief that says that, well, it was reasonable to assume that trial strategies might have been compromised. There's a lot of wiggle room there, and there's not a lot of meat on those bones. I do think that giving documents the morning of trial is not the best, and they didn't follow it, but there needs to be prejudice and there needs to be an abuse of discretion. And then finally, the reasonable efforts question.
What's your understanding of what their argument is? That it was an abuse of discretion to allow the evidence in, or an abuse of discretion to not continue the trial?
My understanding is the latter, that it was an abuse of discretion not to continue the trial.
Did they make an argument the documents should have been excluded?
Well, there were some documents that I think Attorney Perlman, Attorney Curtis did want excluded. A lot of the documents and a lot of the information that was objected to, that I think was relevant, came in DEVANTE, and then there was no motion to strike after that. After that initial ruling, I looked at.
I think that the judge has to make a decision on something that they admit DEVANTE. I think that there has to be a record as to whether it's in or out, and if they don't strike it, then it's in. I mean, if you have a bench trial and the party opposing objects to the evidence, and the judge says, I'll take it to DEVANTE, and then relies on it, the objection's preserved.
I think I have a couple of cases cited in my brief. I think Harris Lewis and Commonwealth versus Navarro, where if evidence is taken to DEVANTE, but there's no motion to strike, it can come into evidence. I think it's incumbent on the trial attorney after the fact.
Okay, I'll take a look at that.
I have two cases.
I'm old, counsel, and that's not my memory of the way the law of evidence used to work, but maybe someone's changed it on me.
I do think it would have been better if the trial judge had actually said when the evidence was coming in or out. But for the hearsay from the New Hampshire witnesses, there was a good reason why she took it to DEVANTE. No one knew if they were going to show up. They had a date in March. The trial started February 26th. They had a date March 25th for all of the New Hampshire witnesses to come in. And she said on the record, well, if they come and testify, I'll do one thing. If they don't come and testify, then I'll do something else. But then it's incumbent on the trial attorney to remember that and move to strike. And he never mentioned it at the hearing. He didn't request more time. And a lot of that evidence is cumulative. I mean, mom herself testified about the referral to New Hampshire DCYF. She testified about the incident. She testified about her grandfather sleeping in the same room as her 12-year-old daughter. She testified about all of that. And her own experts, you could just look at what her own experts said, and they didn't really, they had some good things for her, but saying that she needs to have consistent proof of a reasonably safe residence before the child can go home, that's her own expert. Her own expert said she needs therapy. She needs to buy into it. She hasn't worked on the environmental triggers that led to the child being removed. That's her own expert. And mom said to her own expert, my mental health symptoms are worse now. My anger is worse now than it was at the beginning of the case. So I would agree with Attorney Lynn that there was a lot of evidence in the record that was cumulative. And I think that makes sense because there's been years and years of, again, both of those issues affecting mom's parenting. If there are no other questions, I'm happy to rest on my brief.
All right, seeing none. Thank you very much. These are always difficult cases, and it was a very thorough briefing and some great arguments. Could you unmute Attorney Lynn?
Yes.
Just wanted to add, I'm pretty sure this is the first time we've had the pleasure of having you in front of us. And I want to welcome you to the ranks of our attorneys. There probably isn't going to be many IP litigation cases in the appeals court, but hopefully we will have the pleasure of seeing you again.
Thank you, Your Honor. I really appreciate that.
We are live and on the record.
Thank you very much. I'll call the fifth and final case today. John Doe, number 2453 versus the Sex Offender Registry Board, number 20P457. Probably don't need to say this, but this, of course, is also an impounded case, and we won't be saying the offender's name. We'll call him John Doe. We will hear first for counsel for the offender, Attorney Buckholder. The floor is yours.
Thank you. Good morning, Your Honors. Fred Burkholder for Doe 2453. I know you've read my brief. I do want to add one thing. There's been some development on the case law since my brief was written. I did send a 16L letter yesterday. But in addition to that, and more importantly, with regards to my initial argument, whether or not Factor 2 exceeds, the promulgation of Factor 2 exceeds the legislative authority that was afforded to the registry, I know the court is aware of the fact that Doe 356315 was decided unfavorably. Judge Singh sat on that panel. I do want to bring to the court's attention that I did file an application for further appellate review, was assigned docket number 28183. That was filed on 3/30. And in essence, I just want to read you my introductory paragraph, which will tell you where I believe that issue is. And it's very simply this: as a result of the decision that having time and opportunity may stand in and as a measure of compulsiveness in place of the difficult task of obtaining objective evidence of a perpetrator's thoughts, impulses, and desires, two members of the appellate panel, Blake and Henry, agree that no separate findings of compulsiveness is required, while at least four other appellate court justices, Sullivan, Kinder, Singh, and Milky, believe that compulsiveness is a separately required element. So on the basis of my request for further appellate review, I just want to preserve the argument so that it's before the court. I don't need to belabor it. Judge Singh's heard more than she probably wants to hear out of me with regards to that issue. That said, that's where we go with that. Now, the next thing I want to talk about in this case, and I guess the most important thing I want to talk about.
Well, before we jump out of that.
Yes, sir.
You approach this issue, it seems to me, as if there could not be an affirmance based on the evidence that was presented in the case of your client. In other words, you sort of see it as a binary switch. If the law is that you follow the exact language of the existing regulation, then there could be no. Then that's one thing. If that regulation, instead were read so that compulsiveness still required some individual proof, I'm sorry, I botched up the question, but here's what's really on my mind. Suppose the evidence was such that someone could find that there was compulsion, even if you adopted your position that there has to be separate evidence of compulsion. And could this be that case? Or are you saying you must have expert testimony that he was compelled?
I don't think expert testimony is a prerequisite. And I especially don't think that factor number 2 is a requirement for a classification. There are many cases, which we're both well aware of, where there are no high risk factors that are cited whatsoever, and
Yeah, but
nonetheless.
that's a different point. So here there was a finding on factor 2. There
Yes.
was also evidence that your client engaged in multiple instances of sexual abuse of a child.
And we're talking
Right.
about the facts of this case that's on
Yeah.
appeal today. Okay,
Yeah.
I thought we were talking about the other case.
No,
Okay.
I'm talking about this case. And my question really is, can the facts of the case be sufficient for a finding of compulsivity, even if you accept your argument that compulsivity is a separate requirement, not satisfied simply by separation in time?
The prior panel that decided 356315 would have me would have us believe that. That is not my position. I think the legislature spoke. I think they specifically added the conjunctive term and. I think that the definitions of repetitiveness and compulsiveness have different definitions under Merriam-Webster, which everyone seems to apply. I also think that the judges in that panel agreed with the definition of compulsiveness, which was offered. And as a result of that, we now have 2 separate definitions and 2 separate elements that need to be proven. And despite that, the court says, that particular appellate court says, okay, because the regulations didn't define compulsiveness, then we now get to jump and make the inference that because some time went by and then an action occurred, that was persistence and inability to control. I don't see it that way. I think that by using the term and, they wanted some degree of proof to be offered. And in my
why can't there be sufficient proof here? In your case, where your client was proven to have on multiple occasions over an extended period of time sexually abused a child, why can't that be evidence of compulsivity sufficient to satisfy substantial evidence to find factor 2?
I think that it's a function of the nature of the offense. I think it's a function of the circumstances, the other factors that were in play. And I think that an expert's required to analyze all those things. It's one thing.
That's what I was asking. Your position is an expert testimony is required to reach a finding on factor 2.
Yes. The analysis that I used in my FAR application very briefly is as follows. Someone engages in indecent A and B on a female victim, and then 5 minutes later commits a vaginal rape. There was a time period between those 2 episodes. As a result of that time period, there very well could be an argument made by the board that there was adequate time for that individual to contemplate and understand the severity of his actions and then act accordingly, and that's repetitiveness. I don't agree with that. Whereas if you have a repetitive series of events over a period of days, weeks, months, or years, then I think it more speaks to the psychological components of compulsiveness. Unfortunately, I do some SDP appeals, which—
But isn't that what we have here? Don't we here have the facts that you just described, the latter set of facts?
Yes, but I think you have to look more at other things. You have to look at— basically, I'm getting into the point of a diagnosis as there presently would be under an SDP case where you have a mental abnormality or a personality disorder to suggest that there's a reason, a causation. Merriam defines compulsiveness as a causation. My problem is there is no evidence of causation.
But then that's an argument that you have to have an expert. And obviously, maybe you're aware of what the next question is going to be. But it's name one other factor where we have to have expert testimony before we can find it.
Well, I didn't write the regulations, and as a result of that, I don't think
let's talk about the statute then. I mean, is there any other factor? Is there any factor where this court or the SJC has held you must have expert testimony in order to prove that it exists?
Well, let's talk about offense-free time prior to conviction. That recently was addressed. I forget the exact case number, wherein it was said that that's not addressed by the regulations. And as such, expert testimony is required. That's one thing. The other thing was hepatitis recently.
Expert testimony is required to show what?
Required to show the beneficial mitigating impact of offense-free time prior to incarceration, where there's a period of time that occurs between the offense and the actual time of incarceration. There is a case out there, which I can't remember exactly, but it exists. And I'm sure my brother
But
will.
is that's, but I think that you're talking, go ahead, Judge, sorry.
I seem to recall this was a case where there was maybe a report offered that the judge declined to take. And the court said that they should have taken it, that the judge should have taken that report or that study.
It happened in 22188.
Well, that was Hanson's report. I think the case I'm thinking about is 2344076. Am I right, Mr. Shanaley?
He's muted. He can't tell you.
Oh, I think it's 2344076. And I think that Judge Singh is correct in that there was a proffer made with regards to that, and the board disagreed. In essence, my argument, Your Honors, is as follows. The degree of liberty and impact that a level 2 or 3 classification has upon these individuals warrants a certain degree of due process. And I don't think when a legislature says you must show and for it to exist, and there have been other instances where the term and has been interpreted by this court, such as what's a subsequent offense, and it's been stated to say specifically that both elements are required, and they're defined differently, and yet to be able to say, well, we're going to jump that, and we're going to say because we didn't define it.
Right, I understood. Look, so you, I'm sure, understand from the multiple times that you've addressed this court with this kind of concern that this court is aware of the issue, and that there are judges who feel differently about how this issue should be decided. I want to get past the question of whether the reg is or is not at variance with the statute. Accept the notion that compulsivity and repetitiveness are 2 separate requirements, and get at the point of whether or not the evidence in this case is sufficient to find factor 2, where your client committed, as I recall, at least 3 rapes of an 11-year-old child over a period of weeks.
My answer to your question is no. And the reason for it is because even in 356315, the justices, specifically Justice Blake and Henry, I don't know which wrote the opinion, reference the impact that would be upon the board if they had to bear the responsibility of producing expert testimony. They were aware of it. They know that that's where I'm pushing this thing for, and they're trying to bring up the idea that it's too costly and too troublesome for the board to have to do in every case. And my argument is these are people's lives. I get the phone calls from the guys that are level 3 on the street, can't find a place to go because they had an offense 25 years ago like this man did. And that's the problem that I have with this man here, is that 25 years ago he commits an offense. And then he spends all this time offense-free and does fine. Then the regulations state because he's had an offense within the past 5 years, which he did a stupid thing, and he got himself
a little more than stupid. He shot a gun at somebody.
Well, yeah, all right, and he pled guilty to it. But the point is,
it's an indication of an inability to conform himself to societal standards. Correct?
I don't disagree.
In a serious way.
I don't think it should wipe out everything that he's done. May I read something to the court? This is in the article that I suggested that unfortunately was left out of. There were many things left out of this hearing and the prior motion for judgment on the pleadings that I would have done differently. But this is what Hanson says. In other words, new non-sexual offenses increase the risk of sexual recidivism, but did not erase the sexual offense time-free effect. The effective time free from the sexual offense was independent and incremental. Now, the last paragraph is where I'm going with this. Whereas each year, time free was associated with 12% reduction in sexual recidivism risk, a new non-sexual offense was associated with a 55% increase. Another way of visualizing the effects is that a non-sexual recidivism resets the individual's relative risk to what it would have been 3.3 years previously. So if you take a look at this client, if you take him back to 2011, it still would have been well in excess of 10 years that he would have been offense-free. At least 10 years. My math may be wrong. I'm doing it on the fly. But the point is to assign him no weight whatsoever to his length of time out in the community is an abuse of discretion. I know that's what the regulations require, but you know, we're supposed to under factor 37, we're supposed to look at any other information. We're supposed to look at emerging science. I know the court reads these studies on a continual basis. I do as well. It's amazing to me how much they learn on a daily basis. And to simply say, let me see. I used to do Social Security disability work. And in those particular cases, you had somebody that was 49 years, 354 days old. And as a result of that, they were only closely approaching advanced age rather than advanced age. And under the medical vocational guidelines, they were medium level or a light level, and they didn't get disability. Whereas the next day or 4 hours later at midnight, they were. That's mechanical. And that's what I'm getting at here. Pardon me, sir?
We don't have jurisdiction over Social Security.
I know that, but by analogy, I've been seeing these. I've been doing this for 36 years. You know, I've been seeing these arguments that continuously come, and that's where this leaves me with is, you know, give the guy some credit for all the years that he remained out in the community and didn't commit a sex offense. Call him foolish, call him guilty, call him a criminal for what he did, but don't wipe away everything else that he did. And on top of it, the cases that I brought to the court's attention, I know I'm running out of time, and I'm out of time. The cases that I brought to the court's attention yesterday deal with the very same situation that we have here. We got somebody that's intrafamiliar or close.
Yeah, I think we'll have to leave it there unless my colleagues have some questions.
We have your letter. Thank you.
Thank you.
We do have your letter. Oh, and one thing I should say, would you please do us the favor of when your FAR application is granted or denied, notifying us by a 16L letter?
Of course.
Thank you. All right, well, now we'll hear from the board. Attorney Chanel, the floor is yours.
Thank you, Your Honor. David Chanel for the board, if it pleases the court. Of course, I'm going to rely on DOE 356315 and to answer Judge Englander's question. Is the board's position that this individual's actions fit within the strictures between 22188 and 356315 at threshold weight, which this hearing examiner clearly used this information, repetitive and compulsive, at threshold weight. And you know, it's interesting about the
your position that this person met that because your regulation says that if there's a period of time in between, that's all you need.
It's not. You're right that there's a period of time. It's the period of time with an opportunity to consider the wrongfulness of their actions. Right. Now, I haven't seen any cases where a hearing examiner said that where minutes or even hours differentiated sex offenses, that was repetitive and compulsive. The board has usually used the thumb of at least a period of time that exceeds one individual sexual event. And in this case, we have at least 3 days with 4
different. The board
different
can't
acts.
use a rule of thumb or a regulation to read a statutory term out of the statute. Right?
I don't think I guess I shouldn't say rule of thumb. The board considers when they apply factor 2 that the time or opportunity has to be significant enough for the ability to reflect on the wrongfulness of the actions.
And they equate that to compulsivity. If
Correct.
There's that amount of time, that is equated by the regulation with compulsivity.
Correct. I mean, I think 56315 had the statement that it's the time or opportunity to reflect on the wrongfulness of one's actions, and it not doing so suggests the persistence of the compulsion or impulse to offend. So it's when the facts show that the individual had enough opportunity to reflect on his wrongfulness of his actions that the compulsivity portion of the regulation comes into effect. And again, I think here we have that.
So you know, I mean, we've seen enough of these. So we have a case, I don't think you were counsel, where a child at age 13 dropped his pants in front of a student at school. And then 9 years later, at age 22, that same individual grabbed the behind of a woman in a public library. And because those are separated in time, that satisfies both repetitive and compulsive in the eyes of SORB. Is that right?
Well, it depends. If was he, in the first instance, was he convicted or investigated for that?
He was investigated for that.
Because that takes it to a second level, which is, I mean, there's really 3 levels.
What is the evidence of compulsion in that case?
The evidence of compulsion is the fact that he was investigated for a sex offense and then committed a new sex offense. That's why you have
well, actually, the first one isn't even a sex offense, by the way.
But it's an act of sexual misconduct.
Right.
And that's what this regulation covers, acts of sexual misconduct.
The regulation has to actually be rational with respect to the language of the statute, counsel. And the statute says compulsion, repetitive and compulsive. Right. There is nothing about those 2 acts that suggests compulsion. Nothing. But in the and it's not just a hypothetical, it's a case that was decided within the last 2 weeks.
I know, but there's three levels of compulsion. There's the time and opportunity, and then there's the cases
compulsion. That's the statutory language. You may think there are 3 levels. I think I want to understand what the word means. And honestly, I can't see how SORB is trying to do that. It's problematic for me.
I apologize that it's...
No, you don't need to apologize. I mean, but you're representing SORB, and we keep these cases over and over. Don't apologize. You're doing your job. I understand it. But on the other hand, when you're presenting these arguments to us, we have to address them, and we have to put them in a legal framework, and we have to ask ourselves, does that fit the legal framework that we operate on? Mine is actually to look at the statute and say, okay, it says repetitive and compulsive. Those seem to be 2 different words. What do they mean? And it seems to me that SORB's regulations don't really address that question. Not right.
Well, first of all, the statute says repetitive and compulsive behavior. So that includes, in the board's promulgation, sexual misconduct. It doesn't have to be sexual crimes. It's acts of sexual misconduct. And again, the board has defined compulsiveness as the time and opportunity with the ability to, for the individual to have the ability to contemplate the wrongfulness of his actions. Now, if this court decides that exceeds the board's statutory authority in promulgating this regulation in that manner, that's your prerogative. But right now, based on DOE 356315 and 22188, that's not the case. And I'm not telling this court that it can't change its mind. I'm just saying that right now, as the law stands, this individual fits within repetitive and compulsive behavior as defined by Factor 2.
But the holding of the case that just came out that you're referring to with Judge, if I recall, it has Judge Henry and Judge Blake in the majority. Is that where we are?
Correct.
The holding of that case is that we didn't find the regulation invalid. Is that right?
Correct.
Okay.
But the same panel 3 days later in DOE 24801, which was actually my case, and it was a companion case to this case, they were argued the same day as 356315, said Factor 2 is a properly promulgated regulation and does not exceed SORB's statutory authority. And that was of course, a 123 decision, but the court,
one of the ways to look at that is, does Factor 2, does the regulation compel a finding of compulsion every time you have separation? Or could the hearing examiner, reading that regulation, still conclude that there was no evidence of compulsion in the facts before them?
I think I would say that if there's a period of time and that time is long enough for an individual to reflect on the wrongfulness of their actions, under the regulation, the hearing examiner would have to apply the factor.
It's mandatory in your view? I can tell you that does not jump out at me in the language of that regulation.
Well, first of all,
I know that's how SORB construes it.
well, first of all, the application of any regulatory factor by a hearing examiner is not mandatory. The hearing examiner decides which ones apply or don't apply. And I've seen cases where I may have applied factor 2 and a hearing examiner hasn't applied factor 2. So the hearings, the application of any factor is not mandatory. The hearing examiner has the right to decide which factors apply to a specific case and how much weight to give.
I assume they could do that, taking into account both what the regulation defines as well as an understanding of what the word compulsion means.
Correct. If they wanted to.
Okay.
I mean, again, I can't tell a hearing examiner.
And that might allow the regulation to be not invalid and yet still require SORB to prove something more than a separation in time in order to satisfy factor 2's compulsion requirement. Just saying.
I got kind of confused on the question. I would say that.
Well, I'm trying to make a point, and because I know that you guys do these over and over again. It is presented to us frequently that SORB's position is that if there is a separation in time, then compulsion is shown and must be found. If that's what the regulation said, you could come to one conclusion as to whether it was valid or invalid. If, on the other hand, the regulation was construed as you just suggested it is, which is there is still discretion not to find compulsion, then the regulation could be valid, but you have to show something more than a separation in time. You have to show compulsivity. And that, by the way, is a nuance to the case law that is not identified specifically in the language of the cases you're referring to, but that has occurred to this judge. Let's put it that way.
I think I may have misspoke. What I was saying is a hearing examiner is not required to apply any factor. If a hearing examiner decides they don't want to apply factor 2, they have the right to do that under the regulations. But if they're going to apply factor 2, they have to show that there was repetitive actions and that there was a time and opportunity between the actions for the individual to have an opportunity to consider the wrongfulness of their actions.
And your position is, SORB's position is that's enough alone?
For the threshold weight, yes. And then to increase their weight, that's when you get into investigating or convictions or criminal charges, and then a subsequent misconduct would cause an increase in the weight of the factor. And I think I've addressed the other issues in my brief. I'd only mention that, and I found that I've thought about this, that BB gun incident had another impact in some way. If you look at 3 of the letters of support, his wife, his son, and a neighbor all said that he had the right to use the BB gun to protect them in the shooting. So even his support network is able to, at some point, allow him to act illegally and not call him to account for that. And I think that's an important point on the that factor. But other than that, I would rest on my brief if there's no other questions.
Counselor, it seemed very strange to me in discussing factor 31 that the examiner said that the medical records didn't attest to the conditions as reducing his risk to reoffend. It's not what the regulation says. And of course, I can't imagine a doctor attesting that something reduces someone's rate of sexual recidivism, unless it's Dr. Hansen. What do we do with that? The examiner seeming to think that the records need to attest rather than just describe the limitations.
I think the hearing examiner misspoke. I think the hearing examiner was trying to point out that the medical records do not make a connection between his risk reoffense or degree of dangerous, because he had the same issues in '93 when these events occurred. There was no evidence that that he's legally blind. We know he's lost some eyesight, but we don't know what is. As late as 2014, he could still shoot a BB gun at someone. So there's the reports on this were very old, and they didn't really describe what his current condition was or whether there was an impact. I think that's what the hearing examiner was trying to say. But I can tell you for the first time ever in a recent case I have with a reclassification, a doctor did write that this elderly gentleman, he could not see any foreseeable ability for this man to reoffend, even if he were so inclined. So I have seen it once, which surprised me, but.
That's fascinating. Well, there's no further.
No, I have a couple more questions, if I could. The issue that's being raised about whether there was sufficient evidence of compulsion, was that raised below?
It was in the Superior Court.
It was raised in the Superior Court, but not before the hearing examiner. Is that right?
Right.
Does it
And
have to be
generally
raised
these-
before the hearing examiner, or is it sufficient to raise it in the Superior Court?
You know, generally that's how these things happen. Technically, we could argue that there may be waiver, but we haven't done that because I think these are issues that should be fleshed out in the Superior Court. But so in this case, again, it wasn't raised down below. It went to the Superior Court. It wasn't objected to by the board as waiver, and we're going forward on that. And I think part of that is allowing individuals who are dissatisfied with the hearing examiner's decision to have their issues raised in the Superior Court. Now, if they don't raise the issues in the Superior Court, the board then would obviously argues waiver in the appeals court.
And then the second question is, what about the internet publication issue? He's
I think
55 years
again,
old. He's had one sex offense now 25 years ago.
This is true, and it was
a series of sex offenses now 25 years ago.
Right. And again, 496501 allows us to look at prior sex offending behavior. Now, I have to say, I think the turn on this case for that issue would be the BB gun incident. There's something bothersome about someone who can walk out with a BB gun and start shooting at a car. If that didn't happen, I don't know that we'd be in the same position, but I think in my mind, the BB gun issue shows he still has the ability to act lawlessly and without regard to the safety of others. And I think you can't overlook it. It's an important factor in determining risk and danger.
Well, that seems to be it. Well, thank you very much. We always appreciate the help we get on these cases because they're very complicated to us. So thank you both for some great arguments, some great briefing. That concludes our cases for today. If you were hoping to see SCIASCIA versus Town of Millbury, we have rescheduled that. We haven't picked a new date yet, but it will be rescheduled in the future with this panel. I want to thank counsel in this case. I want to thank counsel in all the cases we've heard. It's just tremendously helpful to the court to get these presentations and to be able to discuss these issues with the counsel. I want to thank our timekeeper and clerk who's kept us going and kept our time running. And of course, I want to thank Clerk Joe Stanton and his entire staff for enabling us to get on Zoom during this pandemic and keep acting with barely a step missed. And with all that being said, court will be adjourned until